Please rise. The justices of the appellate division of the Supreme Court First Department. Hear you, all persons having business with the appellate division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division First Department. Typically, we immediately begin with the call of the calendar. Today is a different day. It is the custom of this court to celebrate the last sitting of one of our own. And this afternoon, I have the distinct honor to pay tribute to my colleague and my sister, the Honorable Angela M. Mazzarelli. Justice Mazzarelli is currently the longest-serving woman associate justice of any appellate court in the state of New York, having dedicated the last 29 years of her exemplary career here in the Appellate Division First Department. Her journey began in the public schools of Southborough, Massachusetts. She went on to graduate with honors from Brandeis University. She then came to New York and earned her Juris Doctor from Columbia University School of Law. She began her career as a legal services lawyer in the South Bronx, where she represented the indigent in the housing and family courts. Justice Mazzarelli served in various capacities within the court system and ultimately entered private practice, specializing in civil litigation. And while I am certain that she was an excellent attorney and advocate, her lasting legacy, without a doubt, is her extraordinary service as a judge in our great state. Justice Mazzarelli has been a trailblazer and has shattered many a glass ceiling. She is the first Italian-American woman elected to the Civil Court in 1985, to the Supreme Court in 1992, and to the Appellate Division in 1994. In total, Justice Mazzarelli has served the judiciary and the citizens of the state of New York for over 37 years with excellence, dedication, and the utmost integrity. Hence, I thought it would be most fitting to present you with 37 yellow roses.
Oh my God. Sally, you come up. Thank you.
Yellow roses are also known as the rose of friendship. And those roses represent each year of your service, 36 there and 1 here. Justice Mazzarelli's appointment to the First Department in December 1994 also marked the elevation of the second woman ever appointed to an appellate court, joining none other than the Honorable Betty Weinberg-Ellerin. After the retirement of presiding Judge Ellerin in 2005, Justice Mazzarelli served as the sole woman Associate Justice to this court until other women justices were elevated to the court beginning in 2008. The depth and breadth of her experience is extraordinary. During her tenure on the Appellate Division First Department, Justice Mazzarelli has sat on approximately 17,500 appeals. She has served with 56 different appellate colleagues and 9 successive presiding justices of this honorable court. Justice Mazzarelli has also been an active leader of the bench and bar, serving in a myriad of capacities over her long and distinguished career. A sampling would include her service as a current member of the New York State Commission on Forensic Science and the State of New York's Commission on Judicial Conduct. She has previously served as chair of the Executive Committee of the Board of Trustees of the Practicing Law Institute, having served as a trustee for over 20 years. She has also served as co-vice chair and member of the New York Patent Jury Instructions Committee for over 10 years. She was also president of the New York State Association of Supreme Court Justices in 1997, and has served as a member of the board of directors of the National Organization of Italian American Women. And while this recitation gives you a basic sense of this incredible woman, I am compelled to share a personal message. Angela Mazzarelli is the heart and soul of this court. She is our historian, our protector, our counselor, and most importantly, she is a member of our family. To say that she will leave a tremendous void in this court is an understatement of gargantuan proportions. Her impending departure at the end of this year brings us all great sadness as we anticipate how sorely she will be missed. For me, it simply won't be the same without her. I know that I am not alone in saying that I have so appreciated her jovial spirit, her wonderful smile, her incredible sense of humor, her sage advice, her kind words of encouragement, and above all, the warm and full embrace you received from her just when you need it the most. Angela, I will forever be grateful for how you took me under your wing, showed me the ropes, guided me through the landmines, and helped grow me into a better appellate judge. We pray that you enjoy in good health your most deserved retirement, and we wish you great success in all the endeavors you choose to pursue. Know that you are eternally loved and will be terribly missed. On behalf of our presiding justice, Rolando Acosta, all of your colleagues, many of whom are here today, and the entire AD1 family, I stand to salute you. And now the Honorable Angela M. Mazzarelli.
Thank you, Judge Manzanet Daniels. To say I'm overwhelmed is a mild statement. Thank you all for that amazing speech, Sally. Your exaggerations of my importance and my accomplishments are most appreciated. Thank you. As I'm sure you all can imagine, this is a big day for me. Most of my professional life has been spent as a justice of this court, here in this absolutely gorgeous courtroom, working with the most extraordinary people. The Appellate Division First Department is a special place. Everyone who works here, every judge, all non-judicial personnel, take great pride in their work and in being a part of the Appellate Division First Department family. I always refer to being a justice of this court, and I'm going to use a phrase that's a little old-fashioned, as the Cadillac of judge jobs. It's the best. I tell every new member of the court that you've just arrived in heaven working here, and I mean it. I have been grateful for every day of the 28 years I've been a member of this court to be allowed to walk into this courthouse, and especially into this magnificent courtroom. And I tell you, I have learned something new and challenging every time I have sat here. Little did I think when I was admitted in this courtroom in 1972 that I would be sitting up here. And I'm going to miss being here, being a part of this court. What I will miss the most are the wonderful people I've come to know here, the fabulous judges who I have worked with over the years, some fantastic people who every day challenge each other's thoughts and conclusions so that we may get it right to better serve the litigants and the citizens of this state. I'm going to miss the clerks of the court, the clerical staff, the court's legal staff, the court officers, the support staff, the maintenance personnel, everyone who works here together to keep this court moving into the future and doing justice as well as it can be done. And I say thank you to each and every one of them. I also say thank you to all of the lawyers who come here to argue their cases and vindicate their clients' rights. We have great lawyers here. As everyone knows, I always say that when we get a pro hoc vici. What do we need somebody from out of state? We have 60,000 fabulous lawyers in the First Department. And we get some of the very best here in this courtroom. And I am also fortunate to have a wonderful staff, and I have had one all the time I've been here in my chambers. Arlene Orsini, my administrative assistant, who is also retiring this year, I refer to fondly as my boss. She is probably the most popular and best-known person in the courthouse. And my court attorneys, my prior court attorney, Linda Byrne, and my current court attorney, Rob Patchen, who have both kept me out of trouble over the years and made me look smart. Thank you. And I do have a couple of family members here I would just like to recognize. My husband, Steve Guarneri, who's here. who I can certainly say is the love of my life. Two of my wonderful nephews, Joseph Mazzarelli and Jackson McCard, and a dear family friend, NYPD Sergeant Frank Sorensen. Now, if I started to mention everyone individually, which I would like to do, who has been kind to me, who's made my days here easier, more productive, those who way back when helped me become a member of this court, and those who taught me what to do as a judge here, and those who are now true friends, I would be here a very, very long time. So let me just say, grazie per tutti. Thank you all for everything. Thank you.
And now I will give my colleagues an opportunity to exit the courtroom before we begin the call of the calendar. No problem. All right, and now the business of the court. The case of People versus Luis Emiliano. I will hear you.
The Your Honor, requesting 6 minutes, reserving 2 for rebuttal.
5 and 2 and 5. Gavin versus Greenwich House. I'm sorry? 10? 6 and 2 and 6. J. Jada. Submitted. Batista versus MTA. Thank you so much. Drummond versus 450 Partners. 4 and 1, 4 and 4. Sarisa versus City of New York. Okay. Okay. 5 and 1 and 5. Okay, then 5 and 1, 4 and 3. People versus Gary Chavanis. Submitted. The next 2 cases will be called and argued together. Right in Realty versus 110 East Realty and 110 East Realty versus Right in Realty. Okay, 8 and 2 and 8. And I want everyone to understand the time clock is for you, not for the court. So if the court has more questions, we will go over the clock. Okay, so worry not. Okay? All right. Polito versus Escorcia. Okay. 5 and 1 and 5. Mac Technology versus Anyvision Interactive.
Good afternoon, for the appellant, 5 and 2, please. For the respondent, 5.
5 and 2 and 5. Donnelly versus Newman.
Good afternoon, for the appellant, 8 and 3.
For cross-respondent Hubert Noonan, I understand we share that for 15 minutes with counsel, so I'll have 6. 6 and 2 rebuttal.
Okay, 6 and 1 and 4 and 4. People versus Leon Tugwell. Submitted. CW Capital Cobalt versus CW Capital Investments.
For appellant, Your Honor, 8 and 4. For respondent, 5, Your Honor.
6 and 2 and 5. Leck versus Leck.
Appellant, 5 and 2, please.
Respondent?
For the respondent, 5, Your Honor.
5 and 1 and 5. Lane versus City of New York is submitted. XL Sports versus E-Ways is submitted. First case on the calendar, People versus Louis Emiliano. You may proceed.
Good afternoon. Thomas Twitchell, pro bono counsel for the appellant, Mr. Emiliano, along with Legal Aid Society. May it please the court. This court should reduce Mr. Emiliano's sentence to the minimum for 3 reasons. First, Mr. Emiliano's sentence is disproportionate to the sentence his co-defendant received. The court below called Mr. Castillo more culpable, more guilty, and more violent. This was the co-defendant. The co-defendant pled to attempted assault in the first degree, a more serious offense.
So your client received 6 years incarceration. The co-defendant, Mr. Castillo, received 7 years incarceration. So it's 1 less year than the co-defendant. Also, you know, it was interesting reading your brief, and I don't know whether this was just an omission, but you kind of glossed over your client's prior convictions.
I believe,
prior conviction, right? Didn't he have a prior conviction and a YO?
yes, Your Honor. In 2016 and 2014, there were prior offenses that I believe were in the facts section, not addressed in the argument. But with respect
that
to
was
the question,
his prior was a violent felony, was it not?
Yes, Your Honor. Mr. Emiliano was sentenced pursuant to a
2 years, I believe, 2 years incarceration and 2 years post-release supervision, I think he received.
That's correct, Your Honor.
And then he also had a YO. I don't recall what the YO was for.
I'm also forgetting exactly what
So given the fact that he had this prior, and also given the fact of the circumstances of this case, why would 6 years incarceration not be appropriate?
Your Honor, to start with the proportionality question in relation to the co-defendant, proportionality is not just a question of whether or not the sentences are different. It's about whether or not they're different enough. And here, that 1 year difference between the sentence is not different enough. It should be
The
reduced.
minimum is 5, is it not?
That's right, Your Honor, which is why we're asking for a reduction to the minimum.
So the co-defendant, Castillo, received 2 years above the minimum. Your client received 1 year above the minimum. And now you want to go back to the minimum. So again, we're talking about that 1 year. I'm not really understanding how it makes a difference in terms of your request, but it doesn't make a difference in terms of the quote-unquote proportionality.
Your Honor, it makes a difference because for a person in their young person in their 20s, a year is a significant amount of time. So it's worth it for this court. It's worth this court's attention to reduce. And given the other mitigating factors in this,
And what would they be?
the other mitigating factors beyond the proportionality question is
Well, the co-defendant, Castillo, I think was 29, right? So he's 29, your client was 21.
28 at the time of the offense. So a 7-year difference between the ages of them. So
Okay.
Beyond that, Mr. Emiliano accepted responsibility for his actions, not just by pleading guilty, but
Well, there
by...
was a video, so it's kind of difficult not to, right?
Your Honor,
I mean, I don't want to confuse cases, but I thought this was the one where the court, the judge actually played the video of the beating, the beatdown of someone who was unknown to them in the street, and then your client I think somebody tried to stop it, and then he pushed them aside, and he kept kicking the person, and then took money from took property from the person's pocket, and this was all captured on video that was played for him, right?
Your Honor, the identity issue is not clear from the video, and there's no evidence on the record that if Mr. Emiliano had not himself shown up at the courthouse as the prosecutor at the plea hearings, shown up at the precinct as the prosecutor at the plea hearing stated, there's no evidence that he otherwise would have been caught, which evidences his acceptance of responsibility and realization that he did something wrong. Other mitigating factors
There
that...
were robbery charges here too, right?
I'm sorry, could you
There were
repeat that, Your Honor?
robbery charges here too, right?
I'm so sorry.
There was an indictment for, the indictment included robbery, didn't it?
Yes, Your Honor.
Wasn't it your client's conduct which caused the robbery charge? Because the video shows that he's the one who took something from the victim's pocket?
Your Honor, I don't believe that's clear from the video, but beyond that.
I think it is. I think that the video clearly shows your client, or the individual who's identified as your client, is the one who actually goes to the pockets and removes something from the pocket of the individual, the victim, as he is lying prostrate on the street. And then Castillo, I think, comes back after that and starts kicking him again.
Your Honor, that wasn't clear from my review of, may I finish my answer, Your Honor?
Yes, you may.
That wasn't clear from my review of the video, but I think more importantly is the fact that neither the government nor the court insisted that Mr. Emiliano plead to robbery in this case, which evidences that both believed that it wasn't a significant part of the underlying conduct.
That doesn't mean, when the prosecution offers a lesser crime as part of a plea deal, that doesn't mean it didn't happen.
No, Your Honor, but in terms of significance towards the underlying conduct that should be punished, that is a relevant consideration.
Thank you. You may proceed.
Good afternoon, Your Honors. Nathan Scher for the people. May it please the court. Your Honors, the defendant's valid waiver of appeal forecloses his excessive sentence claim. But in any event, that sentence was fair and appropriate given the brutality with which defendant acted in the instant case. As the video shows, after the co-defendant hit the victim to the ground, the defendant burst through a small crowd and kicked the victim on the ground.
Does the record cast any light on why it is that defense counsel signed the waiver rather than the defendant himself?
I don't think there's anything in the record that explained exactly why, but what is clear from the record is that the defendant was right next to, or presumably right next to the counsel when he signed the waiver of appeal and consented to his counsel signing the waiver of appeal. But beyond the brutality of the offense, which Your Honors have covered in great detail, defendant here also was has a violent criminal history and also received a very favorable.
So in the briefs, your adversary, they make much of the fact that the judge stated that Mr. Castillo behavior was, that his behavior was far more culpable, I guess, than this defendant's behavior, but yet and still that Mr. Castillo received 2 above the minimum and your client only, and this defendant received 1 above the minimum. So given the fact that Castillo was, again, stated by the judge as being so far more culpable, that again, the proportionality argument.
Yes, Your Honor. I would say that the defendant in our case received a lesser sentence, as you've already described, and also was convicted of a lesser crime in this instance. And so he's already received a proportional sentence based on his conduct. And if there are no further questions,
Thank you.
we ask that you affirm. Thank you.
You have 2 minutes.
Thank you, Your Honor. Just to briefly address the waiver issue, there were issues with the underlying colloquy that the court conducted. Beyond that, the court should have more adequately considered that Mr. Emiliano's youth at the time.
You make much of the fact that the defendant did not himself sign the waiver. Does that invalidate the waiver when the record otherwise indicates that the defendant acquiesced in his counsel signing for him?
It's not dispositive, Your Honor, but the standard under Thomas is the totality of the circumstances. And given the issues with the court's colloquy and
Right, but Thomas also states that there is no set colloquy, there's no set questions that have to be asked of the, during the allocution.
That's right, but here the issues are the court didn't delineate the trial rights from the appellate rights clearly. The court didn't accurately characterize Mr. Emiliano's appellate rights by overlooking his right to challenge the validity of the waiver. The court didn't consider Mr. Emiliano's youth at the time and perhaps difficulty understanding the rights he was being asked to waive. And then finally, as mentioned before, the fact that Mr. Emiliano did not personally sign the waiver, and while there is evidence on the record that he authorized counsel to do that, given his young age, I believe the court should have asked to ascertain why he couldn't sign this document himself that purported to waive his appellate rights. And then just to address the substance of the issue, one final point I would like to make is that Mr. Emiliano is not likely to do this again. He was young at the time of the offense, and by the time he is released, he will be older, in his late 20s, less likely to reoffend. He has a close relationship with his father, who had a stroke when Mr. Emiliano was 9, and Mr. Emiliano spent his childhood taking care of his father, and he is going to be loath to reoffend and risk his ability to spend time with his father again. If there are no further questions, we'll rest on the brief. Thank you.
Thank you so much. And I believe that you are serving as pro bono counsel.
Yes, Your Honor.
The court wants to thank you for that service. We so appreciate it.
Thank you, Your Honor, and thank you
both.
for your 37 years, Justice Mascarelli.
Thank you. Thank you.
Okay.
Sounds like such a long time.
Gabin versus Greenwich House. You may proceed.
Good afternoon, Your Honors. Stephen Seltzer for Appellant Sandra Gabin. May it please the Court. In this case, we have the great benefit of a wealth of precedent issued by dozens of federal trial courts that sit in this geographic jurisdiction as well as in the Second Department that are finely attuned to the language of the governing agreements and governing statutes relative to tolling of the city and state human rights law claims occasioned by the filing of the EEOC charge. So to summarize that statutory interpretation, it's been the case for almost 40 years through New York Court of Appeals precedent.
What's your roadmap for getting the city human rights provision acting as a toll? How do you support that?
Absolutely, Your Honor.
Because there isn't a specific reference to the city, is there, in the applicable code provision?
Okay. There is not a specific reference, but I would submit that the federal courts have handled this exquisitely well and are extremely persuasive in their reasoning, Judge. We have New York City Administrative Code 8-502 sub D, which tolls the statute of limitations for city human rights law claims with the filing either through the City Commission or through the New York State Division of Human Rights. We can then, Your Honor, pivot to the interrelationship with the work-sharing agreement, Section 2C, between EEOC and New York State Division of Human Rights, which states when a charge is filed with one or the other, vice or versa, it is automatically dual filed with the other agency. So given—
Well, the court said that, the court rejected that, stating that the charge, the form, apparently the form, on the form your client did not indicate that it was being filed with any local agency and it didn't include any claims under the state.
I would submit respectfully, Judge, that that is reversible error, and I do have the form. It is page 37 on the record, and if we look at that, near the top is typed in New York State Division of Human Rights and EEOC over state or local agency. That was added in, and we are, of course, dealing with a 3211A1 motion here, Your Honor, so we must have conclusive, unequivocal evidence that that this form eliminates the claim. Again, given the precedent that dual filing is automatic, there is no need to check a box, fill out a form, input anything. But given this document that we have here, it clearly states it is the New York State Division of Human Rights is the local agency. The employer, I am aware, looks above that to a small section on the form which says agency, FIPA, EEOC. EEOC is checked. I would submit to the court, and it's not my intention to go beyond the record, but you can only check one box or the other, and the box that you check will be the lead investigatory agency on that. So that is not anything related to dual filing. I would also submit, Your Honors, that there's been no submission of any regulation policy statement from the EEOC, guidance from the EEOC indicating that the form must be completed in a certain manner in order to achieve dual filing. And there's a very, very good reason for that. It is because given the relationship between the work sharing agreement and the various statutes, it is automatic, and that is what the many federal trial courts have held. It is automatic. It is tolling is not to be determined by the checking of a box or the filling of a form.
Isn't there also to be considered the executive orders issued by Governor Cuomo tolling statute of limitations in any event?
That is exactly so, Justice Mazzarelli, and it is an honor to respond to that on your final day. The second department got that.
My final day as a judge here, let's say.
Your final day with us in the courtroom. I stand corrected. Thank you, Your Honor.
Please.
The second department got that right in Brash, and the second department's analysis.
There's a lot of conversation about Brash and saying that Brash doesn't apply to any kinds of private rights, only statutorily granted rights. But in this instance, it's a statutory issue.
It is exactly a statutory issue, and Brash correctly held that the governor has authority to not just suspend, but to amend and impose other conditions. And the executive orders, of course, specifically reference a tolling in multiple locations within those multiple orders. If the court has nothing further, I will rest.
You'll have time on rebuttal. Thank you.
Thank you, Your Honor.
You may proceed.
Good afternoon, Your Honors. May it please the court. My name is Rebecca McCluskey. I represent the respondent, Greenwich House, Inc. Your Honor, I must start by responding to the point that there's no need to check any box on the EEOC charge form, and that's exactly true. But in this case, Ms. Gavin did check a box. She chose to proceed in the EEOC, and we know that that was the only agency that even had jurisdiction over her claim because she did not assert any state or federal claim in the substance of the complaint. On the record at page 41, she is only pursuing a claim under the Age Discrimination and Employment Act. That is a statute over which the State Division does not have jurisdiction. Pursuant to the work-sharing agreement with the EEOC, the only situation in which the division could go ahead and adjudicate that claim is where there's mutual jurisdiction. But where there's only jurisdiction with the EEOC, it must be transferred back to the EEOC for the determination. Because the statutory language is clear in both the state and the city human rights laws, that the only agency that actually tolls a statute of limitations on a claim brought under either of those statutes is one specifically filed either with the city commission or the state division, and it is not with the EEOC. And that is why Ms. Gavin has to argue instead that it should be deemed cross-filed. But in fact, again, in this case, it should not be deemed cross-filed because it does not assert any city or state causes of action, nor is it vague such that you could imply that there was a federal and a state and a city cause of action. It's clear and it's limited to a federal claim and a federal agency.
I thought you also noted the New York State Division of Human Rights as a state and local agency.
I'm sorry, Your Honor?
I thought she also noted the New York State Division of Human Rights as a state and local agency.
No, she did not at all. That is the form that is just available. I believe you're referring to the top of the page where it just says that would be the state or local agency that would hear her claim. But again, it doesn't have jurisdiction to do so over a purely federal claim. And as to the executive orders are pursuant to a statute that only allows a suspension of statute of limitations. They do not allow a tolling of a statute of limitations, and each executive order can only extend for 30 days with successive 30-day periods. So each time the governor extended, he could again only extend for 30 more days. In the last two executive orders, he said there would be a sunset, the deadline of which this tolling time period would end is November 3rd. So as of November 4th, that is the day by which Ms. Gavin had to file her complaint, and she did not do so. Specifically in the executive orders, the one issued on October 4th says, the suspension is only effective until November 3rd, 2020, and after such date, any such time limit will no longer be tolled. Then again, on November 3rd, the executive order states that the suspension for civil cases that told any time limit for commencement of a case is no longer in effect as of November 4, 2020. The governor could not have, in the first instance, initiated tolling of 228 days. He could only have suspended for 30 days at a time. So it should not be understood, especially where he has a deadline by which the suspension expires. It should not be understood to then actually add almost 200 more days to the time period by which to file.
So you're stating that brash should not be, that brash should be interpreted otherwise?
Correct, Your Honor.
So wait, I want to make sure I understand what your argument is. So you're saying that on November 3rd, that was the last day that it could be filed properly, because since there was no extension, the drop dead date was then the next day.
Correct. November 4th
That's
was
what
when
you're
the stay
saying.
was lifted. Correct. And in this case, on October 11th,
How does a litigant know when, I'm trying to understand that, because there's no way for a litigant to know whether there would be another extension, right? And so you're saying that a litigant then has to guess there's not going to be another extension. And so my statute of limitations dies on the first day that the governor does not extend. That's your argument, that there's no in-between.
no, Your Honor, it was October 4th by which he set the deadline, saying all of the previous extensions were not going to be continued, and the deadline would be November 3rd. So a litigant would know that it's only extended until November 3rd, and that would be the last day, as of October 4th. And on November 3rd, he reiterated that the following day is when it would no longer be in effect.
So on October 3rd, all litigants throughout the state whose actions did not have to be filed because of the stay, on October 3rd, they understood, according to your argument, that you better file your action by November 4th, because that's the drop-dead date once November 3rd passes.
Your Honor, the language
That's your argument?
Correct. That's the language of the both executive orders, the one on October 4th and November 3rd.
Thank you.
I see my time is up.
You have 2 minutes.
Thank you, Your Honors. I listened carefully to opposing counsel's arguments, and as I heard it relative to the charge firm, counsel appeared to have been stating that the statement, New York Division of Human Rights above state or local agency, was pre-printed or already there. I can submit that that was not the case, and that is the problem that opposing counsel and the employer has on a 3211A1 motion that does not conclusively.
Well, that's what I was going to say. We don't know. You're claiming that your client wrote that in.
Correct.
Typed that in.
Yes.
Your adversary appears to be saying that that's a pre-printed form. So
Right,
I didn't understand that.
That is what my adversary appears to be saying. I am saying that is not the case, and the court cannot at this stage on this motion, given the burden of proof, give the employer the inference that it seeks. In any event, given the constructive cross-filing, there is no requirement of any actual filling out the form relative to the agency or checking the box relative to one agency or the other. And I would submit, had the FIPA box been checked, then this would have been sent to the Division of Human Rights for processing, with the EEOC adopting the findings, which was not what was intended. Your Honors, I would also note that there is no requirement in the work-sharing agreement, any of the statutes, or any of the governing precedent that there needs to be some substantive reference to the city or local law claims in the charge. Those agreements and those statutes are very clear. There is filing, there is tolling, there is constructive filing when certain events take place, and they do not include any reference to substantive statements of any particular claims. Thank you, Your Honors.
Thank you. All right, Drummond versus 450 Partners. You may proceed.
Good afternoon, Jonathan Schaub for the defendant appellant. The Supreme Court's order granting plaintiff summary judgment and the 450 defendant's summary judgment should be reversed for a number of reasons. First, there is a question of fact as to the condition in this case was open and obvious and not an inherently dangerous condition. As to the open and obvious question, the plaintiff testified that on the morning of the accident, he walked in and saw the masonite boards. He then stepped on the masonite boards.
Open and obvious only goes to the duty to warn.
Yes, Your Honor, but with the open and obvious and not inherently dangerous, that is a grounds for dismissal. And
Except you haven't gotten to the, it wasn't inherently dangerous since he stepped on it and fell within seconds.
Yes, Your Honor, I appreciate that, and there is a case from the Appellate Division. Now, I understand it's the Second Department and not this court, but there is a case that is held that a masonite board, like in this case, is not an inherently dangerous condition. And in that sense, it's not that it's not.
Doesn't it all depend on how and the manner in which it's placed? So a masonite board that is affixed and not loose might be subject to the interpretation that it's not inherently dangerous, but this was not that.
Well,
right?
I think what
this was a masonite board that was put on the floor in order to save the floor.
And I understand what Your Honor is saying, but I think the key word there is may. There is a question of fact as to whether it was an inherently dangerous condition. In a way, it's not that dissimilar from this court's Lang decision earlier this year that said the red ties on a trash bag were not inherently dangerous.
Well, I was on that case. This is nothing like that case.
Your Honor, what we're saying here is we're not arguing as a matter of law that this was not inherently dangerous. What we're saying is there's a question of fact, which is consistent with this court's decisions, where they have found, for example, that a hole on a hill, there's a question of fact as to whether it's an inherently dangerous condition, or a platform located in a supermarket aisle, whether that's inherently dangerous. Again, not as a matter of law, but as a question of fact. Moving on beyond that, there's also...
The problem a little is when, you have a video production of the accident, which you have over here. I mean, you see the video, you see exactly what happened. It's pretty hard to argue in the face of that video that this wasn't a dangerous condition. I mean, the question is whether there's comparative negligence too, but that doesn't help you to get past the fact that there is negligence for the masonite being on the floor and his falling. Whether he also bears some responsibility, it's a question for a jury, but you just look at the video and you see, as you see him go down immediately, it's really very hard not to come to a conclusion that, yes, it was negligent to put that piece of masonite down on the floor.
Well, Justice Friedman, I'm glad you asked that question because this court actually held that as a matter of law, there was no issue as to comparative fault, and we contend that that in and of itself was an error, and that portion of the court's order should be reversed. Now, I know that doesn't take away summary judgment from the plaintiff under Rodriguez, but as a matter of apportioning fault as it stands right now, the court has said there's no issue as to comparative fault. We agree with you completely that at a minimum, there's a question of fact as to
Well, what was his fault? What did he do that was wrong? Did he run? Did he dance? What?
It was open and obvious. He testified that he saw the Masonite.
Open and obvious, as I said, goes to the duty to warn.
But it's also, if there's an open and obvious defect, and there, in this case we contend that there was, you have an obligation, and it goes to comparative fault as to whether you should have avoided or seen what was there to be seen. He testified that he did see that board.
The only thing he could have done was stopped and say, pick that up, I don't want to stand on it. That's all he could have done.
He could have approached it from a different angle.
How?
He could have walked around not where the boards had been overlapped. He testified he saw this condition here. So our point is, it is, as this court has traditionally held, questions of comparative fault, especially as to open and obvious, are jury questions. That is this court's teaching, and that is what this court has consistently held.
I mean, you don't even need to put it in terms of being open and obvious. It's just, you know, you have to see hazards that are, you have to see what there is to be seen. Whether it's open and obvious, there was a dangerous condition. You're responsible for creating that dangerous condition. Is the one who gets injured by doing that, is there something that he could have done to avoid it, to ameliorate what happens? But
And Justice Friedman, we agree with you in that portion of the order. At a minimum, we believe needs to be reversed so as to allow that issue to be tried to a jury
I don't
consistent
know
with
that
this
it needs
court's
to be
precedent.
reversed. It might be sufficient to clarify it.
Thank you. You may proceed.
Thank you, Your Honors. Marielle Crippen for plaintiff respondent in this case. I just want to address one thing right off the bat. They say that he stepped on the same piece of masonite. That's not true, and it can be seen in the video. The video doesn't only just show him tripping on the masonite, it shows their employee placing it negligently on top of another piece, creating a gap, which is exactly where his foot goes into. You can see that he places it moments before this accident occurs. It's a 2.5-minute video. You see him place it, you see the accident all in that amount of time.
You see the masonite being put down on that, which is what supports the grant of summary judgment on negligence.
And it also supports the finding of no comparative fault on the plaintiff. It is incumbent on the defendant under Perales to show that he had an alternate route to take that he chose not to. There was a scissor lift right there being operated actively next to this defect.
What else? Your adversary implied that there was something your client could have done to avoid tripping on this masonite. What was that something?
I don't think there is anything, and it's their burden on that to prove that. We came forward with evidence, getting rid of all questions of fact. There's no question of fact. They have not raised any issue as to plaintiff's comparative fault. They have to point to there has to be some basis for it. You can't even charge a jury with a comparative fault instruction under Perales unless there's some valid line of reasoning and some facts in the record that show he was in any way negligent. And here, there's nothing.
But wasn't there another gentleman who was to his right, who also went through the turnstile before him?
He didn't go through the turnstile. He stopped and he was standing there and looking through his pockets for a while, and he was on the far edge of there. So that's another spot plaintiff couldn't walk because someone's standing right there.
Right, because then there was the wall. So then the plaintiff to his left is the wall that starts the bank, the elevator bank, and then to his right was that gentleman who stopped. It went through his pockets. And then you had the apparatus to that gentleman's.
The scissor lift, yeah, I believe
that gentleman's right.
The scissor lift was to his right and the wall was to his left.
Right.
And then the individual is there as well. So there
is room between the masonite and the scissor lift.
Perhaps there was, but how is he supposed to even? It has to be a route he knows about and chooses not to take. I'm not sure that there would have been space. He was probably leaving space for the scissor lift because it's a large piece of machinery right there on top of the other masonite board. But to say that he walked over the same board earlier, it's just demonstrably false by the video. It was placed there, and you can see from the video he's not doing anything wrong, looking straight ahead.
How is the masonite going to protect the floor from the scissor lift? They didn't place the scissor lift on top of the masonite.
I'm sorry, Your Honor, what was the
They
question?
didn't place the scissor lift on top of the masonite.
I thought that they did, and that's how they were moving it, or it was in front of them. The scissor lift was right
Not the
there.
way I understood the video, that the scissor lift is to the right, facing it from the doors to the right of the masonite.
But the evidence in the record does say that the owners wanted masonite to be put on the floor in order to protect the floor
From
from
exactly.
the scissor lift and any scuffs
I'm looking
that
at,
the scissor lift might cause to the floor.
exactly, exactly.
And did they set up any like cones or a route for pedestrians coming into the building to
No.
follow to avoid this work underway?
No, they did not cordon off the area, they did not provide any warning, and they admitted that. Their witness actually testified they had no safety plan in place. They did not place any cones or warnings. And it can be also seen in the video, there's not any warning, it's not.
But the owners have been granted summary judgment on common law indemnification. Is that correct?
The owner?
Right.
I
And common law indemnification against AT&B.
They have a non-delegable duty, so they're held vicariously liable for the acts of their contractor. It's a non-delegable duty
But
on
for
the
them
part of
to get summary judgment on common law indemnification means that they've done nothing negligent.
the owner or?
The owner.
This is AT&B's appeal. The owner didn't appeal the order. So AT&B, the contractor, is the one that's appealed this order.
But
saying that
AT&B is appealing the grant of summary judgment to the owners on common law indemnification, is it not?
Yes, they are. That's not an argument I was prepared to, I
It's not
was
your
responding
argument.
to, but they did. But regardless, I mean, part of their argument is that the owner told them to place the masonite. And that may be true, and there is the security guard sitting there, but they didn't, how he placed it, the way it was placed, was negligent, created a hazard, launched an instrument of harm. Plaintiff then fell over it, and he did not do anything to contribute to this accident. And there's no comparative negligence on his part either, I would submit.
Thank you.
Thank you.
Okay. You may proceed.
Good afternoon. I represent the respondent defendant, the owners for this case, and I will focus solely on the common law indemnification aspect. It is our position that the motion court correctly determined that common law indemnification was owed to the 450 defendant respondents by AT&B because AT&B created the alleged conditions such that they were negligent.
What about the issue that AT&B says it was your people who told them to put the masonite down?
Well, I note that the evidence that was submitted that AT&B was instructed to put the masonite down was solely based on the hearsay testimony of their president. He testified that he was not present at the project at the time of the accident.
Is there an affidavit by the owners saying they told no one and instructed no one to put the masonite down?
The owner, my clients, or AT&B? There is
The owners.
There is testimony from our witness that it was solely the responsibility of AT&B.
My question was, is there an affidavit from the owners that an instruction to put down masonite to protect the floors was not requested by the owners?
No, Your Honor.
Okay.
But I would note that for the purposes of common law indemnification, we believe that is not the pertinent issue. And
But wait, if that were true, why would we not hold the owners in if they told their contractor to put down the masonite to protect the floor?
when you say in, do you mean hold them vicariously liable as they
Yes.
were held? When we're not disputing the vicarious liability aspect, we're simply disputing that we were not negligent. We understand that the owner has a non-delegable duty to maintain its premises in a safe condition.
No, the statement was not only that the owner told AT&B to put it down, but also that they gave the masonite.
And again, that was
Which is,
hearsay.
I mean, it's a little different from telling them to put down masonite as opposed to actually giving them the masonite that's supposed to be put down. And then you don't have an affidavit or anything stating that that never occurred. We never gave them the masonite, nor did we ever tell them to put it down.
Well, the evidence that we have submitted is that AT&B's contractors required to provide all materials for the performance of their work. Their owner.
But that wasn't really a material for the work, right?
Well, the use of the scissor lift, because they have to use the scissor lift to get to the area where they had to perform the work. And as Mr. Lyons, AT&B's witness, testified, the use of masonite in the performance with the use of a scissor lift is common in the industry and commonly used.
It's your position that you are out of this, meaning
From a
that
negligence standpoint?
that you get the common law indemnification because AT&B put down the masonite, and that there's no evidence that you have anything to do with their having put down the masonite. But is that really so? Because Lyons testifies, well, we put down masonite, so if he relates a conversation that he has with someone about what to do, yes, maybe that's hearsay and there's no basis to upset the common law indemnification in your favor. But if he testifies we put down masonite, and then you ask him who gave you the masonite to put down, and he says that the masonite came from the owner, is that hearsay?
Well, I would say, just for the purposes of time, that I think the biggest focus here is more so on the fact that there's no evidence in the record that the employee who overlapped the masonite sheet in a negligent manner was instructed by anyone from the 450 defendants to overlap the masonite sheet in the negligent manner which he did, which, as I know that.
But did anyone submit an affidavit denying that the owners asked for that to be done to protect the floors?
To overlap the masonite sheets? No, there's no affidavit that.
So we knew that there was this contention, right, by your contractors that, well, yeah, we put that down, but we were told to do it by the owner.
Well, there is no contention that they were instructed to overlap the masonite sheets.
My question was whether there was an affidavit by the owners or a witness who would have been the person on behalf of the owners who would have issued such an instruction, that they did not issue such an instruction.
And no, Your Honor, there is no such affidavit, but I reiterate that just that alone is not determinative of the issue. The fact is that this individual from
to me, that's the complete issue. But
you want to get out of this. You want to avoid the impact of the question that Judge Masonet just asked you by saying, look, AT&B put down the masonite. They're responsible for doing that, and there's no admissible evidence that we had anything to do with that.
Well, that is correct.
That was a friendly question.
Yes, that is correct. And continuing on that, there's no evidence that they were instructed to, the employee was instructed to place it in the negligent manner.
AT&B was responsible for the work. There's no admissible evidence that there is evidence that they were instructed, but you would, of course, say that that's hearsay evidence.
Correct.
But there's no admissible evidence that anyone told AT&B what to do. They put down the masonite. That was a negligent act. They're responsible for it. We're vicariously liable, but we're entitled to indemnification. That's your position in a nutshell. Is that?
That is correct, Your Honor.
Thank you. You may proceed.
3 brief points. The first is we know there was a safe way to traverse this area in and out because we know that the plaintiff walked out of the turnstile before to go pick up his lunch and turned around. So we know that there was a way to safely navigate this area.
Wasn't that before the masonite was put down?
The masonite was down, but this was a new piece that was added, but he was still, the scissor lift was in the same place. He could have come and
So
walked.
how is that relevant? I'm not understanding. The masonite is put down after he actually left the building.
So there was 5 turnstiles. He could have used one of the other turnstiles.
Was there room for that?
We just went through this. We, and talked about where everyone was placed in terms of the scissor lift. I mean, we all saw the video, okay?
Right.
We watched it. So we know where everyone was positioned. So I'm not really understanding your argument that, he went out and he didn't fall.
He didn't need to walk over that specific piece of masonry.
And you didn't need to do that kind of work when the building was being used by people walking in and out. Why did you do it in the middle of the night when there's nobody there?
But again, he had the ability, he needed to see what was there to be seen, and this is a question of comparative fault. This is not saying he has no right to recovery, it's just a jury
Have you read the
question.
Rodriguez case, Rodriguez versus the City of New York?
Yes. And then just briefly, I'll be very, very brief.
You're out of time.
Okay, thank you.
You've got
Justice-
your record and your brief. Thank you.
Thank you, Justice Mazzarelli, and have a great day.
Thank you.
Okay. Cereza versus City of New York. You may proceed.
Thank you. My name is Evie Kazansky. I represent Howland Construction. The procedural posture of this case was a summary judgment motion made by Howland, and then thereafter a motion to renew and re-argue. It's been long the stare decisis of this court that if a contractor shows it does not do work at an accident location.
But did the contractor actually show that? I mean, we have complaints. First, we have work orders for that area, and then we also have a number of complaints. So how is Highland showing that there's no issue of fact whatsoever that they did work at that location?
With respect to the timeline of all the documentation, I think we put that in our brief.
Well, what about permit M01-21532-5-A15, which was issued to Con Edison for the period of November 21st, 2015 to 12/20/2015. How does Howland show that they had no involvement with that permit, with that work, and that the plaintiff didn't fall? When the plaintiff fell, it's from the work done under that permit. How have you established that?
So, if I'm understanding you correct, what happened is Howland was brought in late into the case. By that point, the plaintiff had there was clear evidence of where the plaintiff fell. I'm going to answer your question. So that was in front of 301 East 69th Street. That's undisputed. With respect to the 3 street opening permits that we're discussing, apparently Con Ed finally gave over to the plaintiff.
Okay, so the permit identification that I gave you, do we know that that was not in front of 301 East 69th Street?
So what I was going to say was, with respect to the permits, yes, the street opening tickets that were provided by Con Ed show that the one specific one in November of 2015, the record 244, was actually A15, and that was the one done by Howland. The other ones in the street opening tickets are not by Howland.
How do we know that? The drawing suggests that there were cuts made on, East 69th Street on both sides of the street. So how do we know that Howland didn't work on any of those cuts in front of 301 East 69th Street?
The only street opening ticket provided by Con Ed with respect to Howland was at the record 244, which is at the corner of the 2nd Avenue.
But the drawings suggest that cuts were made on both sides of the street, both sides of the street.
You are referring to which?
The one that Justice Friedman made reference to, M01, 201, right.
A15.
A15.
A15, letter
Right.
A15.
A15.
How do we know that Howland didn't do that work and that didn't encompass 301 East 69th Street?
A115 clearly shows its start.
A15.
A15, I'm sorry, which is at the record at 244, shows that Howland started its cut at 2nd Avenue. The plaintiff's accident, 301, is in the middle of the street. Then Howland, even if Howland did the work, giving them every favorable inference, was on the southeast side of the street. This accident happened in the middle of the street on the north side. Secondarily, This was in 2015. Number one,
I mean, that was to repair a gas leak. It's not going to be a very limited opening, is it? I mean,
no, Your Honor, this court has dealt with these cases over and over again, and most recently, a decision was made on October 4th, 2022, which you were a part of, where Triumph showed that 5 years before an accident, there was other work done subsequent. So my point to this permit is, number one, it was in 2015, 2 years before the accident. Number two, all of the documentation plaintiff already had. He had the corrective action reports that show subsequent work in and around 301. Specifically, there were complaints and a car action reports from the city of New York, which was the first accident.
Counsel, I'm giving you some leeway, but as you see, you are well beyond your life.
I understand that. So I just wanted to say that the documentation clearly shows that in the subsequent time frame, from 2015 up until March of 2017, there was at least Daniela being complained of as their plates in front of 301.
Okay,
And
thank you. You'll have time on rebuttal. You may proceed, counsel.
Thank you, Your Honor. Andrew Padover from Crouse and Classmith for plaintiff respondent. If it may please the court. The issue in this case is there is a discrepancy in the facts. We filed a lawsuit after this accident, and
Is there any discrepancy as to exactly where your client tripped on the pothole, or where the pothole was located?
there is no discrepancy about where he fell. The discrepancy is the fact that we got records showing, so essentially we started a lawsuit, discovery proceeded, we got records saying defendant, appellant here, did work on the street. So we filed a subsequent lawsuit against them. They, in response, filed a motion. They attached an affidavit saying we never did work on that street, which we already know is incorrect based on those records. Court came back and denied it, saying this is a question that needs more discovery.
So your client claims that he tripped on the pothole at 301, in front of 301 East 69th Street. Is there anything showing that Hallen actually worked near 301 East 69th Street?
So it's near this intersection that they're talking about. So could they have? We know that he didn't fall
Counsel,
at the
I'm going to suggest to you that you really focus your arguments on the standard of proof required here. We don't deal in perhaps, maybe, okay?
Okay.
So focus your arguments, counsel.
Okay.
So Hallen is claiming that they did not do any work near 301 East 69th Street, and even if they did so in 2015 and not in 2017 when this occurred, and also there was subsequent work done in that area after they left.
So for that argument, the issue is they produced records, and they alleged they did work for 2 years prior to this accident when it shows that it was
right
within
at the
2
corner.
years.
They allege that they did the work at the corner, and you're in middle of the block with this, aren't you?
We are not in the middle of the block. We are closer to the corner,
How many feet away?
probably 30 to 50 feet.
Is that in the record, or are you just like guesstimating?
That's approximately.
Is it in the record?
It is not
I
in the
don't
record,
know that I
no.
saw anything in the record in terms of how far it was from the corner.
No, it is not.
And don't tell us that.
I mean, the 2-year elapse wouldn't save them. I mean, if they left a dangerous condition in 2015, they'd still be responsible for almost 2 years later.
Yes, the point is
But
that
the question is, did they leave a dangerous condition in front of 301 East 69th Street? And you could clarify what evidence there is that they're responsible for that pothole.
the evidence is this is an argument about it was premature and discovery is still needed.
But it was also because there was evidence, as my colleague alluded to earlier in her questioning, that there was some evidence that there were cuts on both sides of the street, meaning east and west.
Yes.
And so that although perhaps the first cuts were on the opposite side of the street, ultimately, there were additional cuts on the opposite side of the street in front of 301 East 69th Street. And that's what the record bears out, at least questionably, correct?
Correct.
Anything else?
That's all. Thank you.
Thank you. You're next.
Good afternoon, Your Honors. Gregory Bakos for defendants, respondents, City of New York, Department of Transportation, MTA, and Judd Law Contracting. I just want to bring to the court's attention that on appeal, Howland focuses on the specific location of the cuts made in the roadway, whether at the intersection of, on 2nd Avenue on the intersection or on 69th Street. However, plaintiff alleges to have tripped in a pothole, not in a cut mark. Howland admits on appeal.
Well, over time, couldn't a cut mark become a pothole?
It most definitely could.
Absolutely.
However, Howland admits on appeal that this work was performed a mere 2 car lengths away from the specific accident location as testified to by plaintiff. Accordingly, any argument that Howland's work was performed nowhere near the accident location is disingenuous. Given this, parties should be
I mean,
afforded
the way Supreme Court left this is not the end of the story. I mean, Supreme Court permits Howland to make another motion for summary judgment after discovering.
Of course. I submit that parties should be afforded the opportunity to depose Howland as to the scope of work, the specific location of the work, the equipment and manpower used, methods and procedures employed in performing the work, the length of the project, and any post-accident inspections that were performed.
Well, Howland does claim that they were out of the area in 2015, and again, this incident occurred in 2017, and that there was other work being done between 2015 and 2017.
Correct, but I don't believe that any work that was performed after Howland's work necessarily supersedes a cause and create argument made against Howland.
Well, it depends on what that work is, right?
Correct, but we have no discovery, we have no depositions, we don't know the scope of the work, we don't know any of the information that I just listed.
So at the very least, the motion for summary judgment by Howland was premature.
Correct.
Okay.
Thank you.
Thank you. All right.
I would submit to you that it wasn't premature. By the time that Howland was brought into the case, the plaintiff had already deposed the city, had all the corrective action.
Had they deposed you,
Not
your
yet.
client? Well, then therein lies the problem.
That normally I would say yes, but with all the documentation, with respect to the cut across the street, if you're looking at the record at 245, that wasn't by Howland. It says it was by MGO. But with respect to the need for discovery, as the court has noted, Howland's going to come in and look at the street opening ticket, as well as Con Ed, who did not oppose Howland, but opposed Daniela and put in Daniela's contract. Daniela was there. I'm not saying that Daniela's at fault either, but Daniela was there by the corrective action reports in 2016 with specific complaints about their plates in front of 301. Then secondarily, there's also specific complaints about the 2nd Avenue subway, which is the city's project, and their construction and machinery. Even if you make the reference that Howland did cuts on the southeast side, they did not do the final restorations, and they were not there for a year and a half, and nobody in those corrective action reports stated anything about Howland's work. And therefore, it wasn't premature, and Howland should have been granted summary judgment.
Thank you so
And good luck to you, Judge Mazzarelli. Congratulations.
Thank you very much.
Okay. Ryden Realty versus 110 East 138th Realty. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Robert Spolzino from the Abrams-Fensterman firm, and I represent the appellant, 110 East 38th Realty. The motion court here held, and the respondent argues, that not owning the property at all can be a permissible exception to title in a real estate transaction. That cannot be the law. This case isn't about marketable title. It's about title at all. The seller did not own a portion of the premises that he agreed to sell.
But you did know about it, didn't you?
Well, in that regard,
Because you take subject, there's a permissible exception, including the 1995 covenant. The 1995 covenant references a map 8 parcel 16 and a map 8 parcel 17. And when you look at that, it takes you back to the 1983, which tips you off that you lack title, or that there's an issue with the title at a portion of the property.
well, Justice Friedman, I think tips you off, which is what I think you said, is probably an accurate way to look at it. The covenant that's referenced in the contract is not the notice of appropriation. It simply references this one appropriation in a lengthy list of other appropriations. The covenant has to do with use of the property, has nothing to do with anything else. So I think it's possible to say that, yes, it was referenced there, but I don't think it's fair to say that by reason of that reference, the purchaser knew what was going on. Or
why not? All persons or entities entering into a contract are assumed to have read the full contract and understand all of its terms. Why should your client be held to a different standard than that?
Well, Your Honor, the full contract here says that the permitted exceptions, which is what we're talking about, which is what their argument is, only matter if they don't render title unmarketable. That's section 13.01 of the contract, and it applies to everything in Schedule B.
The entity from which your client purchased this property obtained this property with the very same restriction, no? With the very same, no?
I don't know that from the record, Your Honor. I know that this appropriation occurred in 1983.
My reading of the record said that the party from whom your clients bought this property obtained the property in the same way that your client was getting it, with the same documentation regarding this particular sliver of the land, no?
And they may well have.
Does that cast any light on the subject of whether selling with that encumbrance or easement, however you refer to it, does that cast any light on the subject of whether that's marketable title?
I'm sorry, Your Honor, I couldn't hear the
Does the fact that the person you're buying from bought it with the same issue, does that cast any light on the subject of the marketability of the title?
No. My client agreed to buy a particular piece of property described in Schedule A of the contract. The seller didn't own the property, all of the property that he contracted to sell. He warranted that he did. He said the contract says that at the time of the contract and at the time of the closing, he owns the property. And that was simply not true. Calling this some issue of permitted exceptions can't matter because not owning the property can't be a permissible exception to title. And even if you look at the contract, as I said, paragraph 13.01, if it renders the exceptions only apply if they don't render title unmarketable. Title can't be title that you don't have can't be marketable title. It's just a matter of definition. So there was no basis.
Other than your clients espousing that statement, is there any declaration by any entity that says this is an unmarketable title?
Well,
Other than your client?
Judge, well, first of all, the insurer wouldn't insure it, which is when this issue came up. But secondly, we've searched the precedent for this, and we found no precedent, no case I've cited, no case the respondent has cited, where a seller claimed that it didn't breach the contract even though it didn't own all the property. There's simply no precedent for that because it can't be true. The second argument that the respondent makes is that my client waited too long. I'm sorry.
Let me ask you something about the due diligence. Section 17.05 provides that if the purchaser fails to file the termination notice prior to the expiration of the due diligence period, purchasers shall be deemed to have waived the right to cancel this contract. Haven't you raised this well past the due diligence period, and haven't you thereby lost the right to rely on this?
I was about to get to that, Justice Friedman, thank you. But there's a little bit more to that sentence, if I may. It says, purchaser, this is page 118 of one of the records. I apologize, I don't remember which one it is. Purchaser shall be deemed to have waived the right to cancel this contract as provided in this Article 17. So the time limit applied to Article 17 termination, which was for any reason or no reason. The appellant didn't terminate under Article 17. The appellant terminated under Article 4, which says if you don't have title, if seller doesn't have title, purchaser can cancel the contract. So this was not untimely at all. And in fact, there's an argument it was premature because part of the warranty is you have title at closing. He could have waited till the closing, and when the seller tendered the deed, said, that's not what I bought. So the idea that this is untimely.
But when you were purchasing the property, you knew about the 1983 appropriation, did you not?
Not when the contract was signed, no. The only knowledge of that came when the title report came in after the contract.
And so was there a termination sent?
There was
a letter.
Ultimately, there was. Not right away.
When you say ultimately, how much time went by?
Several years, during which time my client was paying millions of dollars to keep the contract alive. But each of those.
Well, that's what I do not understand. I mean, I don't get it. You're saying that they didn't have title, the title wasn't marketable, and you're saying that they didn't know about the 1983 appropriation, but until the contract is signed, and then they don't do anything about it? Your client doesn't do anything about it?
This is a question, Justice Weber, of his contractual rights. Under the terms of each of those extensions of the contract, the entire contract was extended except the portion that was changed. And the amendments didn't change any of this provision. So the entire contract includes Section 4, which says they have to have title at the time of the contract and at the time of closing. There's no time limitation.
What do you do with Exception 13 of Schedule B, which includes covenants, restrictions, easements, agreements of record, as of the date hereof, provided the same do not prohibit the present use of the premises for its present purpose. So this is clearly something which, when you look at the record, you know about it. So why isn't Exception 13 ultimately a problem to your position?
And to add to that, you mentioned that your client wasn't able to get insurance, that you couldn't insure the property, right?
Which he found out after he had signed the contract. But
way before he terminated.
Right, but there's no time limit, Justice
Really?
President. There was no time limit for him to terminate under Section 4. That was only under.
So what about
Section
Justice
17.
Friedman?
What about Exception 13?
Right.
13, you're referring to Exception 13.
Exception 13 of Schedule B.
I go back to Section 13, I think it's 13.01 of the contract, which says that everything in Schedule B is not an objection if it renders title unmarketable. That's the overriding provision, 13.01 of the contract.
13 doesn't mean anything in respect to the section you just mentioned.
It means something, but.
Right, finish your answer. We've gone over your time by at least 4 minutes already. So you've eaten up your rebuttal time. So I want you to finish your response to that, and then let's hear the other side.
It's okay.
If I may, I was just answering questions, Justice Menzies.
I didn't excoriate you for that. I said, finish your answer to her question, but you've gone over. So I need you to wrap it up.
May I still have my rebuttal?
Yes.
Oh, thank you. I thought you were taking my rebuttal away.
No, I was just saying, hurry up so I don't take away your rebuttal.
Okay. Thank you, Your Honor.
Counsel, I will hear from you now.
Thank you, Your Honor. Evan Freed for the respondent. May it please the court.
So let's turn, do you have marketable title in view of this sliver?
Absolutely, Your Honor.
And how do you get to that?
The cases that we've cited in our brief, which go uncontested by the appellant, address precisely this point. And there are 3 points that I want to emphasize. I'm going to start with my third one first. And you hit the nail on the head. My client purchased the property in 2000 subject to the 1983 appropriation. The 1983 appropriation, the appellant admits, was filed against the premises in 1983. The cornerstone of marketable title is whether the purchaser stands to inherit title in the same condition that the seller has enjoyed it.
So you mean if you agreed to buy unmarketable title in 1983 or 1985 or 2000, that means he has to agree to take unmarketable title? Does the fact that you bought it make it marketable?
Yes, it does, but I'm going to raise 2 more points here. First of all,
So did you disclose?
What's the best case which stands for that proposition?
Laba v. Carey. Laba v. Carey, we cite time and time again throughout our brief, a 1971 Court of Appeals decision. Laba v. Carey says not only that, but Laba v. Carey also says that you can't swallow the permitted exceptions. In that case, the court goes through the permitted exceptions, the exact same permitted exceptions we're talking about here. Exception 10, which is the statement of facts, and Exception 13, the matters of record. And then the court goes on.
Did you specifically disclose that 1983 issue in the contract?
Absolutely. At least three of our permitted exceptions disclose the 1983 appropriation.
That's not, I don't mean this in any pejorative sense. It's not really 100% accurate. It's accurate in the sense you disclose the 1995, and when you get to 1995, you can't help but know about 1983. Isn't that more precise?
If you're asking whether we specifically say the 1983 appropriation, no, we don't. But Laba v. Carey makes clear that you don't have to do that. We're talking about the same exact permitted exceptions as was accepted in Laba v. Carey. The statement of facts, and let's remember that the 1983 appropriation was disclosed in a November 2017 title report, which was incorporated into the Second Amendment. This is 2 weeks into the contract for sale. And let's also remember that Exception 13 matters.
At which time your adversary's client had an opportunity to pull out.
Absolutely. They had the right to cancel the contract for any reason or no reason at all.
When did they get
somebody?
When did they get the title report?
2 weeks into the contract, Your Honor.
And how much time goes by before this claim of a right to terminate because of what that title report shows is raised?
They received the title report the last week of November 2017. The due diligence period ends the second week of February 2018. Between February 2018 and the cancellation, mind you, May 2020 amidst COVID, more than 2 years pass, and the buyer makes over $2 million of an additional down payments and adjournment payments. And the buyer enters into 2 written amendments in March 2018 and April 2019, each time ratifying and confirming the provisions of the original contract. They waived the right to terminate. If there ever was a marketability or a warranty issue, which there was not, they waived the right to terminate the contract pursuant to Section 1705 of the contract. The purchaser shall be deemed to have waived the right to terminate as set forth in Article 17 if they do not deliver that termination notice by mid-February 2018.
Let me just turn your attention to something else. You do make a representation that you don't know of any condemnations here. Isn't that so? The contract so provides.
Laba v. Carey says.
But the fact is that you do know of a condemnation because you know of the 1983 taking.
Subject to the permitted exceptions. Laba v. Carey makes clear that when a contract contemplates permitted exceptions, all the provisions of the contract are made subject to the permitted exceptions. But this contract goes further. Section 18.8 expressly says that to the extent there's a discrepancy between the main contract and the riders of the schedules, simply defer to the riders of the schedules. Schedule B here says you have to look at the record, you have to look at the statement of facts, you have to look at this 1995 covenant. The Schedule B, the permitted exceptions, provides an impenetrable thicket of myriad ways where we've disclosed the 1983 appropriation. It was absolutely disclosed, and the purchaser was required to accept title subject to the permitted exception, and all the warranties, the marketability provisions, anything in the contract is made subject to the permitted exceptions. Laba v. Carey addresses this exact scenario time and time again. We provide a mountain of case law in our briefs concerning this point. The same thing happens every single time.
How much time would you say from the time that those items were made available to the buyers? How much time did they have that information prior to the expiration of their due diligence time period?
First of all, the contract provides the over-accurate language. So as a technical matter, the purchaser's on inquiry notice prior to signing the contract. But in terms of actual notice, they received the title report the last week in November. They had an additional all December, all January, about more than 2.5 months prior to the expiration of the due diligence period. Mind you, in January, they also entered into the First Amendment, extending the due diligence period. So they had an extra month beyond that. They waived the right to terminate as set forth in Section 1705. Laba v. Carey, my client is entitled to retain the down payment as liquidated damages, like clockwork.
What you're saying, I think, is that they knew about this problem at the end of 2017 when they still had a right to get out under the due diligence period, and they weren't concerned about it at that point.
I like to call this contract, Your Honor, the three-strike rule. They were obligated to search the record prior to entering into the contract. They had a second strike. They could have canceled for any reason or no reason at all during the due diligence period, but you don't get 3 strikes. You don't get to waive the right to terminate in mid-2018 and wait 2+ years to call up my client amidst COVID and say, oh, we found this 1983 appropriation. This looks like a good grounds to cancel the contract. You don't get 3 strikes, Your Honor.
Thank you.
Thank you.
Well, you do, but you're out.
Thank you.
You don't need to answer that.
I couldn't resist.
On your last day here, this is my first day here. So thank you for everything.
You have 2 minutes.
Thank you, Your Honor. But you're not out when the contract says you can get out and cancel the contract. And the contract extensions all preserve the entire contract, including the right to terminate. Section 18.8, which says the schedule's
Why would you wait such a long time to exercise termination? Why would you sit on your hands like that and pay all that extra money?
I don't know, Justice Mazzarelli, but it's not in the record. This is summary judgment motion to dismiss, so maybe that's an issue down the road, but it's not here. And they had a right under the contract. You don't have to, there's no time limit on the exercise of that right. Secondly, Laba against Carey doesn't matter. It had to do with a waiver of grade restrictions. It has nothing to do with a situation where there's no title. And third, Section 18.8 can't override the conflict between Schedule A and Schedule B and 1301, which says that it governs and a title has to be unmarketable to be an exception. Finally, let me just conclude by saying, as someone who had the great opportunity to serve in the Appellate Division for a small portion of Justice Mazzarelli's tenure, it's my honor to be here today and to congratulate you and thank you for all of your service, and hopefully in the not-too-distant future, welcome you to this side of the council table.
Thank you very much.
Thank you. Thank you. Polito versus Escorcia. You may proceed.
Good afternoon, and may it please the court. I'm Chloe Moon on behalf of the appellant, City of New York. Supreme Court's decision here, relying primarily on a single trial-level decision, ignored this court's and the Court of Appeals' consistent and recent precedent. First, as this court recognized as recently as May of this year in Mendez v. City of New York, a plaintiff fails to plead a special duty, whereas here they allege insufficient factual predicate for that duty. Plaintiff here did not plead or show facts demonstrating that the city owed a special duty to her specifically. And as in Mendez, even assuming plaintiff had properly notified and pled a special duty, an allegation that the plaintiff was directed to proceed through traffic is not enough to create that special duty. And even if this court doesn't agree with us on special duty, Supreme Court erred here in denying summary judgment as governmental immunity applies. As this court has said over and over, traffic control—
if our citizens of this state understood the case law that predominates in this area, you wouldn't have many citizens listening to traffic cops. Is the problem with this case, right? Because if I have a traffic officer say, sure, go ahead, I am, as a driver, assuming it is safe to do so.
Yes.
That's a problem here. It's a real problem. And we are creating a dangerous situation for the citizens of this state, because if I can't rely on an officer who's waving me through, we're going to have a lot more accidents out there.
Well, I think my response to that would just be that this whole immunity doctrine developed in order to protect discretionary decisions by government officials so that their decisions aren't second-guessed. And that's exactly what this court has said over
But
and
this
over.
case is a perfect example of how that should be second-guessed. We had an officer who said, go ahead, go on in. And the driver does what the officer says and then hits a pedestrian.
And I think the answer to that is that governmental immunity presumes some amount of negligence, right? And that's the point of having this immunity doctrine, so that the city is protected from these kind of suits when the damage is created by a third party.
Am I correct that there's no issue that the pedestrian was illegally crossing the street or improperly crossing the street?
Sorry, could you repeat the question?
The pedestrian was lawfully in the street.
Lawfully, yes, correct. Yes, and
the pedestrian is lawfully in the street, and the police, I'm sure every single person in this courtroom has been in this position. They're lawfully crossing the street. There's a traffic officer there, and now the traffic officer directs someone to hit them.
Yes, Your Honor, but ultimately that goes back to the special duty question, which is that she—
I was wondering, I was just thinking about this.
Yeah.
If I'm crossing the street and the light is broken, right, or the light is, for some reason, it's showing green for both me, and it's also showing green for the person, in this case, I guess she's making a left, right, onto First Avenue? Yeah, she's making a left onto First Avenue. If the light is broken and it's an issue as to the light, would I, as a pedestrian, have a cause of action?
I think a broken light is a separate question, largely
I
because
would
the
have
reliance—
a cause of action, but my point, would I not have a cause of action? Because the light, I have a green, and also the vehicle has a green?
I mean, I think actually the answer is no.
So what do you think, yes or no? I'm thinking yes.
And I would disagree with that
thinking
because—
yes, if under those circumstances where there's a broken light and I have a green and the vehicle has a green, why is that so different from this traffic agent who is waving on the driver to make a left when the pedestrian's crossing the street?
And I think the answer is—
the same thing?
I do understand, Your Honor, and I think the answer is, the reason why my answer was different on the broken light question is because the special duty, ultimately, that doctrine is asking for an affirmative undertaking by the city. And neither the broken light—
Not to wave cars on to, as my colleague said, hit pedestrians.
Affirmative undertaking by the city to the specific plaintiff, an assurance of her safety. So saying something like, I'll make sure you cross this street safely, and walking her with her across—
Look, the bottom line is the message is to all people on the streets of the city of New York and drivers in cars on the city of New York, before you listen to a traffic agent, check for yourself. That really is the bottom line here.
And you just said that, you know, a duty to her by, specifically to her. If the traffic agent is telling her, yeah, cross, is that not a duty to her? Is that agent not specifically stating to her, yes, you're clear to go?
That's a part
I'm
of
helping you cross?
Yes, Your Honor. That's a part of the traffic agent's duty at large to the public. That's what he's doing there. He's telling the public to cross the street. So that's not specific. It's not creating that special relationship that the Cuffey factors.
Well, many times there's one person crossing and the traffic agent nods to that one person. Cross, does that create a special duty?
No, Your Honor, simply because it's the same part of that duty to the public at large, that's the function of why
So
they're
you
there.
are at your own peril when the traffic...
Exactly.
I'm not being,
Exactly.
You're at your own peril when the traffic agent tells you to cross the street, nods her head, says to you, go ahead, and then directs the car to hit you. I mean...
So there would never be a special duty with a traffic agent?
I wouldn't go so far as to say that. I think
Can you
there
think
could
of
be
an
a
example
specific...
where there would be a special duty?
If the agent went over to the specific plaintiff, offered his arm, and said, I'll make sure that you get across this...
So just waving is not enough. He'd actually have to assist the person.
As this court has said multiple times, the waving is not enough, the gesturing is not enough. And simply here, you have that, and you also have the governmental immunity doctrine, which protects the city here, as this court has said over and over. And for these reasons, we ask this court to reverse.
Thank you. So am I right that you accept the instructions of a traffic officer on the streets of New York at your peril?
Absolutely, Your Honor. And my name is Michael Ligatese for the respondent plaintiff. The facts are even more egregious than what you explained. When the plaintiff got to that corner, she was waved on by the traffic agent. And at that moment, she was hesitant to proceed. So there was words from the traffic agent said, you can come now. And that's where the special duty is created. Not only by just waving her on, but by saying you can come now.
Sir, I'm sorry, but on page 217 of the record, your client, in her deposition, made clear that the traffic cop was really speaking to the group. He wasn't speaking to her. In fact, it says, and when he directed his attention to you, that was as a group, not you individually. Answer, it was a group of us. Am I correct, sir?
You are correct, Your Honor.
So it was not a specific representation by the traffic officer to your client specifically, let me hold your hand and help you across.
Well, I think to the contrary, and what your colleagues and justices were alluding to earlier was that the appellant was saying that each traffic agent would have to walk, physically take each individual and walk them across the street to create a special duty, which is, absurd to have that distinction. When there is a small group of people, and it wasn't until the plaintiff testified that the agent said, you can walk now, until they trusted the agent to walk across the street. And at that very moment, the agent turned their back and overriding a red light, had another vehicle make a left-hand turn through that red light. And the other facts that...
I thought it was a turn signal. Wasn't it a turn signal? No? I'm sorry. Was there not I thought it was a turn signal.
At that moment, there was a red light that did turn to that turn signal.
Oh.
And the traffic agent directed that driver to proceed through the intersection while putting a plaintiff there. And the lower court relied upon the decision in Sacchetti. Yes, that's a lower court decision, but it's analogous to our case in that they ruled that they overrode that traffic light. If there is a functioning traffic light, they should not have overrode it, and they should not have, the traffic agent should not have voluntarily assumed that duty to override it. And what's different in our case from some of the other appellate decisions is that the traffic agents in the other appellate cases directed one way of traffic. But the traffic agent in our case put the actual plaintiff there and put the other defendant in the same exact location, in violation, what they held in Sacchetti, of their own manual. So what the city is saying is that we can violate our own safety manual. We can violate our own internal procedures, but there's governmental immunity. So we can harm those individuals that are trusting our traffic agents to cross them across the street and say, nope, there's governmental immunity. We're not responsible for the harm that we've caused. And the lower court was correct to say that they did, in fact, cause that accident. And the facts remain the same from the defendant, the co-defendant driver, the passenger within that vehicle, the plaintiff, and the police report, which was attached to the notice of claim and incorporated by reference into the brief, which said that that agent directed the defendant to drive through the intersection and strike that plaintiff. The appellant also argues that we didn't plead a special duty properly. However, the lower court properly addresses that we pled it, and they cited to our complaint line after line, that the traffic agent assumed an affirmative duty to protect the plaintiff while she was well within the intersection. And there are several other lines, and not only did we plead it in our complaint, but we did it well above what was necessary to prove that there was a special duty. Your Honors, there's an appellate case, Mullen, that's directly on point with our case, where the court held in that instance that there was a special duty owed to the individual plaintiff when they were assured by the inspector that it was okay to enter into the shoring. And they fell down and they passed in that specific instance.
Well, in that case, it was stated that the city had the city was liable because of its actual knowledge of the dangerous condition and its failure to do anything about it at a time when the inspector was on hand. That involved an 11-foot trench that the inspector apparently fell into, so it's a little different.
I'm glad that you brought that up, Your Honor.
I'm going to give you 30 seconds because you're out of time, okay?
Sure. The counter to that, Your Honor, is that the city is arguing that it isn't an inherent danger, that the traffic agent that is trained to understand the intersections, even a layperson, using common sense would know that directing two individuals, an innocent plaintiff, pedestrian, and a driver with a multi-ton vehicle at the same location would cause a collision. So it is inherently dangerous. They know that a dangerous condition would exist at an intersection. It's well known to a layperson, it's well known to a traffic agent, and I think it's directly analogous in our case.
Thank you.
Thank you.
Your counsel, you have 1 minute.
Just quickly, Your Honors, as the colloquy made clear, plaintiff was told, as she alleged in her deposition, that she could now cross with a group. It wasn't specific to her. She never made it. She never said anything about it being specific to her. There was no reliance. She also said in her deposition that she wasn't paying attention.
That's why she crossed the street.
She said she wasn't even paying attention to the agent, that she was relying on the traffic light that was the correct light for her at that moment. As to Justice Weber's question, it was a flashing yellow turn signal for the driver. And then just one quick point.
But of course, all drivers must stop their vehicles to pedestrians in a crosswalk, right?
Yes, although
so the fact that they had a yellow flashing light was irrelevant to that particular mandate under the VTL, right?
It's also irrelevant to the fact that the city is immune. And ultimately, these bald legal recitations in the complaint that were just restatements of the Cuffey factors, they don't get around the fact that there was insufficient factual predicate here, which is what this court said in Mendez. And thank you so much.
Thank you. Mac Technology versus AnyVision Interactive. You may proceed.
Thank you. Just bear with me 1 minute.
No problem.
Hearing aids always pop off when I take my mask
I
off.
gotcha.
Bear with me 1 second. Thank you so much. May it please the court, Leonard Lesser for the appellant, Anyvision. We're here on an appeal on a motion for a partial dismissal based upon a very clear contract that expired 8 months before a transaction took place wherein the plaintiff is now claiming a referral fee, well beyond the termination of the agreement. This is a clearly defined provision in the referral agreement, a niche capped defined term, TERM, which is 3 years from a capitalized defined term called effective date of November 23rd, 2017. That is the term. That is the clearly expressed defined term of the agreement.
Let me turn your attention to Amendment B of August 24th, 2018, page 80 of the non-confidential record. So when, at the end of paragraph 1, it says, unless, in italics, unless otherwise defined, capitalized terms used herein shall have the meaning ascribed to them under the agreement. What does that mean?
What does it mean? It means exactly what you have ruled, Justice Friedman, on at least 3 recent cases. When you have defined terms in an agreement, capitalized, defined terms in the agreement, that is what the agreement says.
But it says capitalized terms used herein. Presumably that refers to the amendment.
What it says is, very clearly, unless otherwise defined, the capitalized terms used herein shall have the meaning ascribed to them under the agreement. So the capitalized term as used herein in the Second Amendment, and that is the, quote, term, capital T.
So what are the capitalized terms in the amendment that support your position?
It is.
What are the capitalized terms in the, I don't think you heard. What are the capitalized terms in the amendment that support your position?
The capitalized term in the amendment is in subsection C of the new Exhibit B, which says, in the event the company and the approved investor or the previously approved investor consummates any of the following transactions during the term, capital TERM.
Except that the agreement also envisioned that there may be payments beyond the term based on transactions that occurred during the term, correct?
That's a different type of transaction. The original referral agreement dealt with product referrals. So if you had a product referral and there was a renewal of that, that could apply. But this Second Amendment was a discrete type of referral fee for an investment transaction, an equity investment transaction. So this provision that allowed for additional referral fees if there was a renewal doesn't apply here because it was very clear what the parties intended. And it couldn't have been any clearer because their Second Amendment made that term clear.
It's not clear. It's not clear to me. This phrase which reads, each of the undersigned hereby agrees that the with effect as of the day hereof and notwithstanding anything to the contrary, etc. I don't understand what agrees that with effect as of the date hereof means.
Yes, remember.
So explain that to me.
Remember, Judge, that is in Section 2 of the Second Amendment. So Section 1 of the Second Amendment makes it perfectly clear that we're adopting the capitalized defined terms in the referral agreement.
But what does that, what does the section I just read to you mean?
All that means is that from the date of this Second Amendment, this new Exhibit B supplants the former Exhibit B and will apply. And the reason that was done...
That does not, it doesn't say that at all clearly.
But it does say that.
To say the least. This is one of the worst sentences I've seen in a contract.
I will say this with respect to that. You could pick apart...
Not even grammatically correct.
You could pick apart the grammar in that sentence, but it does nothing to impact the express provisions in italicized in Section 1, which says, unless otherwise defined, the capitalized terms used herein have the meaning ascribed in the referral agreement. And that initial term, TERM, is in Section 3B. This second provision in paragraph 2 that you're speaking of, and that Judge Crane decided created some sort of ambiguity, doesn't do it. Because, first of all, it's not a defined term, effect hereof, right? Whereas the effective date is a defined term that's adopted specifically in the Second Amendment.
All right, I'm going to allow you to finish.
Sure.
Go ahead.
What impact is there on your position by the fact that Belknap says that Epstein told them that they're going to be paid?
That has to do with not the claim that we moved to dismiss on. So there were a series of transactions. There were 2 AIAs, Advanced Investment Agreements, where it was essentially bridge financing. And there was a separate discrete investment transaction in July of 2021. So with respect to the conversion of the earlier AIAs, Advanced Investments, what the plaintiff is alleging through this hearsay statement is Eckstein said, okay, upon the conversion of those prior bridge financings, we will pay you a commission. That's the alleged hearsay. Because of that hearsay, we didn't move to dismiss that claim. We moved to dismiss the claim that she's allegedly entitled to a referral fee on the fresh money purchase of Class C shares on July 8th, 2021, 8 months after the defined term built into the Second Amendment passed.
Okay, you'll have time on rebuttal.
Thank you so much.
Good afternoon. Christoph Heisenberg for respondents. The fallacy to the argument.
So if the parties intended the amendment to extend the term of the deal to 3 years from the date of the amendment, why didn't the amendment include redefinitions of defined terms, effective date, and term, both of which are defined in the original agreement?
The answer to that is in the definition of term. Contrary to what the appellant is arguing, the term here is defined only as a period of 3 years. The argument that it extends to the first clause in that sentence, that the effective date commences, is directly contrary to the rules of interpretation that this court, including Your Honor, used in Dwayne Reed versus Cardtronics 2008. That is, that if there is a definition or a reference in a phrase, qualifying words or clauses ordinarily are applied to the words or phrases immediately preceding.
But don't you run into the problem that paragraph 6 of the August 2018 amendment, except as specifically provided above, any agreement as amended hereby shall remain unchanged as originally constituted?
Correct.
How do you get out of that?
We are not disputing that the term remains unaltered. The term, however, as defined, is only the 3-year period. The definition,
from the original date.
No, respectfully, when reading it, it says, the agreement shall commence on the effective date. That doesn't speak to the term. And shall remain in force for a period of 3 years, and that's defined as the term. So the term is
What
only...
does the rest of that sentence say?
Pardon?
What does the rest of the sentence say after 3 years?
Unless earlier terminated in accordance with Section 8.2. And so the definition, using the last antecedent rule of construction, which this court has used, is that the definition only encompasses the immediately preceding phrase, which is the period of 3 years. It does not encompass the initial clause in that sentence, which has a separate point, which is this agreement. It doesn't say the term shall commence on the effective date. It says this agreement. And so when you get to the August 2018
But then it says the term may be extended.
Yes. So it was, and that's exactly why
Isn't the term 3 years?
The term is 3 years, and it is viewed that if there was a further transaction, as there was an amendment, then that 3 years would shift. So that's why they did not.
But the amendment didn't shift to 3 years.
I'm sorry, it didn't
The
what?
amendment doesn't say we're shifting to 3 years.
It doesn't need to. The amendment itself creates a new contract, and that we cited the case law for that in our brief. That is not at all disputed on theirs, that a new contract, and it says as to the new terms, and this claim is solely under the August 2018 amendment. It doesn't encompass the other previous agreement. That then says...
But when you get to 3C, in the event the company and an approved investor or the previously approved investor consummates any of the following transactions during the term capitalized, that by this very amendment, the italicized provision in paragraph 1 takes you back to the 3-year term of the original agreement.
It does. And so putting those
Which is not changed.
Right. Putting those two pieces together, the term for purposes of the August 2018 amendment starts on that time period. Now, if they had written it that the original term shall commence on the effective date, then the much stronger argument would be made that the term is not just the 3-year period, which the rule of the last antecedent says, but rather it applies to the entire sentence. But if you look throughout the rest of this agreement, there are numerous instances of compound sentences where the first clause will address...
But at the end of the day, there's nothing in Amendment B which says that the 3-year term is being changed. On the contrary, paragraph 6 says it's not being changed since it has not been specifically changed.
Right, and maybe I'm not making myself clear. The term, the 3-year period, is not being changed. It is going to be 3 years from the August 2018 date. The only issue is whether the term defined encompasses not just the 3 years, but the first part of where the sentence in which it appeared initially. And by the rule of the last antecedent, that is not the construction that you would place on it. You only apply the sentence immediately preceding the definition, which is the 3-year period.
But what you're saying is that 3-year term in the original agreement had no beginning and had no ending.
No, for purposes of it says, for purposes of this agreement.
It's a floating term. It's, you know, when you look at it, it didn't mean anything. It didn't mean that there was a begin date and it didn't mean there was an end date.
Not quite, because for purposes of the agreement and the section 8.1 that we're looking at.
It certainly, as drafted originally, had a beginning date and an end date.
Yes.
For you to change it, it had to be specifically changed. The amendment says as much.
The original sentence in which the term is included has two components. It has the first clause, which says, this agreement shall commence on the effective date. And then it has a second part, which says, it also shall run for a 3-year period, which is the term. Putting those two together clearly...
The term may be extended by the written agreement of both parties.
Correct.
There's nothing which agrees to an extension of that term.
And the term, the 3-year period, is not being extended. That still is there. It is being shifted because it has a new commencement date. And the original statement, which says, this agreement shall commence, has no application to a later agreement, which says it has its own new starting commencement date. So the essence of their argument is that term is not just the 3-year period in that clause that immediately precedes the definition, but that it includes the statement about the commencement date. And that's not the way that the interpretation works under the rule of the last antecedent.
So just to deal with some of the other points that came up during Appellant's argument, the provision for payments to be made even over as much as 6 years, and the fact that you could have a continuing, which is an argument you make that you could have a continuing, he refutes that by saying this is just about that stock, the first cause of action about the stock investment made in plaintiff and defendant. Are you in disagreement with that?
Yes, there is a factual dispute, and because we're at a pre-pleading stage here, I do not accept the argument that the July 2021 investment is new money or unrelated to the earlier investments. The clause says we are entitled to monies paid or payable from those investments, and the assertion, which has nothing in the record here, that it is a separate transaction is contrary to our pleading, and since we've pleaded this and we're at a pleading stage, we do dispute that.
I believe my colleague.
Right, I just wanted to clear up a little bit as to what Justice Friedman was asking you. So essentially, you agree that term, with an initial T, as Mr. Lesser points out, because I read that in his original argument before Judge Crane below in the transcript. That term means 3 years. Correct. So you agree term means 3 years.
Yes.
Where you disagree, and you accept that term as incorporated in the 2018 amendment, correct?
Yes.
What you're saying is, with the phrase, with the effect of, as of the date hereof, that term of 3 years starts here in 2018 for another 3 years. Am I correct?
Yes, the first half of that sentence pertains by its terms to this agreement. So for the original agreement, that undoubtedly that term, the 3-year period runs from that.
Even though there's nothing in the amendment which says that?
Correct. By virtue of the fact that an amendment constitutes a new separate agreement, and that was unrefuted in the briefing, and it has an effective date, even if it's spelled differently.
The first agreement unless it's specifically changed.
Right,
Paragraph 6.
And the fact that effective date with a capital E and F pertains to the First Amendment only, it would not need to be altered because that remains true even after the Second Amendment in August of 2018. It's just that it has no effect on the commencement date of that second agreement. That second agreement comes into being and into force, whether it says it correct, with the correct words, but by law, it comes into effect August of 2018. 3 years from that date brings us to within this transaction.
Thank you.
Thank you.
Counsel, you have 2 minutes on rebuttal.
Thank you so much. Let me just quickly take this off. Again, these hearing aids, bear with me. So, to accept what counsel just told the court would be to completely rewrite the agreement, right? Because the agreement, and remember, we're not dealing with two separate agreements. The Second Amendment is Exhibit B to the referral agreement. They're not separate agreements. The definition of term in 8.1 of the agreement could not be clearer. It's one sentence. Quote, this agreement shall commence on the effective date, capped terms, capital E effective, capital D date, which is defined in the preamble of the agreement as November 23rd, 2017, and shall remain in effect for a period of 3 years unless terminated in accordance with section 8.2, paren term, in quotes. You can't excise the defined term effective date of November 23rd, 2017 from the definition of the word term. And as Justice Friedman, you pointed out right at the beginning of this argument, the Second Amendment, which is only adding the new Exhibit B to the referral agreement, could not have been clearer in paragraph 1 in italics to make it, and that's italics in original, to make it perfectly clear to these sophisticated contracting parties, unless otherwise defined, capitalized terms used herein shall have the meaning ascribed to them under the agreement. So you have to go back to section 8.1, which is the definition of the word term, cap term, which is then used in the new Exhibit B for any additional equity investment that is made by this approved investor in any vision during the term, then they get their referral fee. You cannot excise what counsel is doing, the definition of effective date, to try to say we have new agreements here.
Your time is up, and I'm sure Judge Massanet is going to make you leave the podium right away. So just before you do, what is your response to counsel's claim that there's an issue of fact about the continuing payment?
There's no issue of fact there, because the Second Amendment couldn't have been clearer. You only get a referral fee if there's an additional equity investment that closes, meaning money is invested into any vision during the term. It doesn't give rise to this open-ended sophistry, essentially, that if there's a future investment long after the term expires, somehow, some way, that then gets referred back to an original investment. The agreement specifically says otherwise. Referral fees are only earned for additional investments during the term.
Did I get it? Am I correct if what you said was that this appeal really relates to just the first cause of action?
I'm so sorry.
That this appeal relates to just the first cause of action?
You'll have to do it one more time, Justice Friedman.
That this appeal relates to just the first cause of action?
This appeal refers to, it's a partial motion to dismiss the claim for a referral fee on the July 8th, 2021 investment by this one approved investor into Eldridge, not the conversion of the prior AIAs. That's a separate, discrete provision in the July 8th, 2021 agreement. We're just talking about their claim for a $1.25 million referral fee on an equity investment made 8 months after the defined term of the agreement clearly expired. And that's why we believe Justice Crane did get this wrong in finding some sort of ambiguity in the clear words that were used in the parties' agreements. Thank you very much.
Donnelly versus Newman. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Gary Friedman, and I represent the petitioner, appellant, cross-respondent Belinda Newman. She's one of 3 daughters of the decedent and the preliminary executor of her estate. We respectfully submit that the surrogate's court erred in not dismissing the objection to probate based on undue influence and constructive fraud. The drafting attorney, Amy Holtzman, an experienced trust and estates lawyer, testified on the day after that she initially met with Belinda. She spent over an hour on the telephone with the decedent, took copious notes of what decedent wanted in her will. She produced the notes of that conversation. She also had several subsequent telephone conversations with the decedent, including at least 2 of them on the very morning of the day that the will was executed. Belinda was not present at Rusk Institute when the will was executed. The only people there were the decedent, Ms. Holtzman, another lawyer, a matrimonial lawyer, a colleague of Amy Holtzman, and Amy Holtzman's paralegal, who was there to notarize the self-proving affidavit. The testimony was that Ms. Holtzman read the dispositive provisions of the will to the decedent, explaining what they meant, and the decedent then proceeded to sign the will, and the witnesses then signed the will. The case law is clear. Influence alone does not invalidate a will. To invalidate a will, it must be shown that the influence amounted to a moral coercion which restrained independent action and destroyed free agency. Here, the objectants rely merely upon conclusory allegations. To defeat summary judgment, they were obligated to show facts entirely inconsistent with the hypothesis that the execution of the will was procured by any means other than undue influence. They certainly did not. Here, the decedent explained to Amy Holtzman, why she was treating her daughters differently. It's in her notes, it's in the will. She said that her daughter Melissa had substantial means. She was married to a very wealthy husband. She testified that her...
Counsel, again, why is it not an issue of fact, a question of fact, to determine whether or not, one, there's a confidential relationship, and two, whether or not there was undue influence? I mean, given the circumstances, given the relationship, she's in the rehab center, there are some issues in terms of statements that she made. There are some issues in terms of who paid for the attorney, things of that nature. Why should that not just go to a trier of fact?
Well, the reason, Your Honor, is that... I moved this, I'm sorry. The reason is that they have to show, to establish a confidential relationship, you have to show that the decedent was dependent upon the person, the alleged undue influence, the person in the confidential relationship. And here, that's not the case. What you had was a loving daughter tending to her mother in the hospital. Her needs, you know, her needs for the activities of daily living were being met by the staff at Rusk. They were providing food, they were doing the bathing. This is not one of those situations where it's an elderly relative who is locked away. There's no testimony whatsoever that Belinda isolated the decedent. Her sisters were free to visit her at Rusk if they so chose. And as the Second Department noted in the Zirinsky case, that the fact that the proponent, even if the court determines that she was in a confidential relationship, it's counterbalanced by the closeness of the family relationship, the relationship of mother and daughter.
Yeah, but counsel, I mean, you know, I've done these cases in the past. You have that relationship, you know, in almost all of these cases where you have one sibling who may be closer to the decedent than another sibling. But the case law is kind of clear from my understanding, is that, you know, whether or not there is a confidential relationship is something that we normally leave to the trier of fact to make that determination, looking at all of the circumstances and looking at all the facts.
Only if there's sufficient evidence to warrant submitting the issue of whether or not there's a confidential relationship as a matter of fact. And one of the most telling facts here is that 2 months before the decedent died, one of the other daughters had a lawyer call the decedent to see if she could get her to change her will. And Amy Holtzman learned of it, and then she contacted the decedent and said to her, you know, Mrs. Newman, would you like to change your will? And she responded, no, not at this time. So if Mrs. Newman felt that she was pressured into doing the will 15 months beforehand, she certainly had an opportunity to change her mind in the ensuing 15 months. She never did. And concerning testamentary capacity, well, I'll reserve that for my rebuttal.
Thank you.
Thank you.
Please, the court. My name is John Morkin. I represent the respondent, cross-appellant Hubert Newman. I'm going to address the undue influence issue and confidential relationship. My colleague, Don Novick, who represents Melissa Newman, will address the cross-appeal on capacity. Undue influence. In a nutshell, what we're talking about is whether the March 4, 2015 will reflects Dolores's intent, freely, knowledgeably given, or Belinda's. And where we want to start with that is what was going on. We have, for 16 years, since 1999, a will in place giving everything to the 3 daughters, I've been talking about the residuary, 3 daughters equally, and all the grandchildren taken care of in some way. Here we have, in extremis, on February 19, 2015, a will done that completely changes anything. What was the urgency? She was going in for a hip replacement because of that broken hip, but there was no urgency on March 4. What was the urgency?
Did there need to be an urgency?
There was none.
Did there need to be one to change one's will?
Only if you thought so, because this was an opportunity for Belinda to accomplish that fact.
No, you're not hearing my question. Does there have to be some emergent situation to change one's will.
Not at all. If you want to do it, and of course, she had gone many years without changing her will.
That doesn't mean she didn't wake up one day and say, you know, I want to change that will.
Except that she didn't wake up one day. It happened in the hospital and then in the rehab.
Well, she woke up there too, right?
But here's what I would want to address. What happened with the will, the characteristics of it. What stands out is that Melissa Newman's children completely ignored. When you look at this will and say,
But
what
she
happened?
apparently gave reasons to her counsel at that time for why she was preferring one daughter over the other daughter.
Nothing mentioned, Your Honor, with respect to those children who she.
Oh, yes, it did.
Not
It said that Melissa was married, right? Do I have the right sister?
She was married, absolutely.
That she was married to a wealthy man and that her and her children were well cared for.
And-
That was the reason that this decedent gave to her counsel for the changing of that particular gift.
And she also had another reason for the other daughter. It was a different kind of reason, but she articulated to
And that reason, Your Honor, was only motivated because on February 26, 1 week later, Belinda, who denies this ever occurred, went to see Amy Holtzman and for 2 hours sat down with her and said, we got to change the will so that Christina gets something and Melissa gets something. But
And
with an
other than your
interim clause.
conjecture, what proof is there about what you just said, that she went to Attorney Holtzman and asked her to change the will, et cetera? What proof?
It's documented, Your Honor, by the notes of
That
Amy
she
Holtzman.
went and told
Yes.
Holtzman we have
She wrote down, now listen, please. She testified under oath, Belinda, that Dolores never told her to go see Amy Holtzman. She denied ever going to see Amy Holtzman. She denied ever knowing the contents of that will, and yet, according to Amy Holtzman, and her notes indicate it and confirm, Belinda, on February 26th, went to see her, sat down with her for 2 hours, and Amy Holtzman wrote down what Belinda told her would be in the will, which included this bequest to Melissa and a bequest to Christina with an interim clause. How in the world did that come about except Belinda communicated it? That's exactly what Amy Holtzman testified.
So again, why should this not go before the trier of fact to make a determination as to whether it occurred or not?
It must go before before a trier of fact. That's what we're saying. Summary judgment should not be granted. This is for a fact finder, Your Honor. And I mean, Judge May is very capable on this, and she wrote it very well and very clearly with regard to confidential relationship and undue influence. That this would be for an issue for the jury to find and conclude on.
Okay, thank you.
Thank you, Your Honor.
Counsel, I'm going to give you an additional minute since you have a cross appeal.
Honors, good afternoon. My name is Donald Novick, and I represent Melissa Newman on her cross appeal, and I'm going to confine my comments to the issue of capacity, testamentary capacity. I'd like to point out one of the a case that was decided by this court, Rella versus Sciano, 278 AD 2nd 136. It's in the memos of law, and this is what this court said in that case. An issue of fact as to the decedent's testamentary capacity is raised by the sworn statements of one of the decedent's children who was a doctor, and similar statements by the objectant that when the decedent executed the codicil, some 5 months before she died at the age of 89, she was in deteriorated physical, emotional, and mental states, suffering from arteriosclerosis, often crying, depressed and forgetful, and was taking medications that have mind-altering side effects, including Valium, Darvon, and Librox.
And none of that was present here. None of that was present here. I know, and you made reference to this in the briefs, but I didn't see anything showing that the decedent was in any type of deteriorating condition.
Beyond regular old age,
Well,
right?
If you look at the report of Dr. Fogel, the opinion of Dr. Fogel,
That's your
that's our expert.
who never saw the...
He never treated.
His entire opinion is based on medical records and conversations with the litigant.
Yeah, exactly. But he does cite in his report all of the ailments that she was suffering from, and also the 13 discrete medications that she was taking, some of which can have an effect on your mental status.
Okay, so what do we do then about matter of, what is it, Giaquinto? I think it's Giaquinto, right? So we have the attestation of the witnesses stating that the decedent was of sound mind, right? So isn't that presumptive?
No, I don't think it's not a presumption that applies.
Isn't that what Giaquinto says?
Yeah, but it's a presumption that can be rebutted.
Okay, so how have you rebutted that? That's what did you present to rebut that, other than this this expert, quote unquote, expert testimony from this doctor who's relying solely upon the medical records?
Well, that's why the medical records are important, because the medical records say that on the day the will was signed, she was anxious, upset, and highly emotional. And on top of that,
but then we also have the attestation that she was of sound mind.
right, that's where the issue of fact comes in. And on March 5th, the day after, she told the staff that lawyers were coming to discuss a divorce and doing a will. She didn't even remember that on March 4th she had already signed a will. And she didn't remember on March 4th that she had signed a will.
So as you know, counsel, the cases where we talk about the execution of the will, the issue is the decedent's state of mind at the time the will was executed. There are numerous cases where if the will is executed now at 4:30, but at 5 o'clock, the decedent makes, strange statements, the will is still presumed to be valid, assuming there are attestations that the decedent was of sound mind.
Well, I think you also have to consider the fact that she was totally paranoid. She thought that her $30 million plus painting could be taken by the storage facility in which that painting was stored.
It could be if she didn't pay the money.
Yeah, but she wasn't paying the money. It was being paid by her husband.
But again, I understand your arguments, but again, the cases are pretty clear in terms of the execution of the will at the decedent's state of mind at the time of the execution.
Well, then how do you explain the Rella case? Because the Rella case says that you can take her medical condition into consideration when determining whether she had testamentary capacity. And in this case, the ailments that she was suffering from appear to be more severe than the one in Rella. And you combine that with the fact that she had this paranoia, she didn't know she had executed a will the day before, and she may not have had testamentary capacity, but that's an issue of fact that has to be decided by the trier of the facts.
Okay, thank you.
Thank you.
Wait, there's one more rebuttal.
Thank you, Your Honors. On the day that the will was executed, Ms. Holtzman and Orit Hershkovitz, the other lawyer, spent over 2 hours discussing matters, the will, her relationship with her husband, her relationship with her children. This wasn't one of those will executions where they're there for 20 minutes. They couldn't make a determination as to whether or not the testator was capacitated or was suffering from, was acting under restraint. And although the objectants keep pointing to, well, she was anxious, she was depressed, neither they nor their medical expert point to anything in any of the medical records that shows that her cognitive abilities were impaired. Matter of fact, on March 5th, the day after the will was executed, she met with a psychologist. And actually, the objectants make a lot about it, saying, oh, this shows that she was paranoid. The psychologist began her report by saying the patient, and this is at 3642 of the record, the patient was alert and oriented ×4. Communication was clear, coherent, and well organized. Her distress is well substantiated by concern's voice. She demonstrates self-awareness and emotional control along with ability to listen. The introduction, indeed the entire report, is hardly the description of a person who is acting irrationally.
Thank you.
Thank you, Your Honors.
All right. CW Capital Cobalt versus CW Capital Investment. You may proceed.
Good afternoon. My name is Greg Cross. I represent CW Capital Investments, which I'll refer to as CWCI, and CW Capital Asset Management, its affiliate, which I'll refer to as CWCA or CWCAM, whichever comes out, because I use both. So let me first say it's great to be back in person.
So it's your position that the federal action really covers what's being litigated here. But nevertheless, when Cobalt sought to intervene in the federal action, you opposed their motion on the grounds that it would inject collateral issues into the case. How, in the light of that position, do you come now and say, well, this is all the same?
Well, because we weren't talking about collateral issues. I did take that position because I didn't want the sweep of allegations in this case put into the federal action. The argument with respect to the issues that were in front of Judge Fela, did the foreclosure judgment change the rate? Was CWCA entitled to the fee? Those had been litigated for 2 years already in the federal action, and the question there was, were there
Didn't that relate to Stuyvesant Town, whereas this action concerns the fact that CWCI settles the Metzko action and doesn't take account of its fiduciary duties to Cobalt?
No, that's not what this action says. There are only 15 paragraphs in the complaint that relate to this action. They start at paragraph 95, they run through paragraph 109. And what it says at paragraph 95, introducing it, nowhere was Cobalt's ability to block CWCA from selling REO properties, not settling, selling REO properties.
The federal action did relate, did it not, to dealing with the proceeds from the sale of Stuyvesant Town. Is that right or wrong?
Can you say that, related to what from the sale? I couldn't hear you, I'm sorry.
The allocation of proceeds from the sale of Stuyvesant Town.
That's one way to characterize it. What the federal action determined was CW Capital Asset Management's entitlement to penalty interest, and it had squarely in front of it whether the foreclosure judgment had changed the rate of accrual of interest.
So the question, I'll put it a different way. Did the federal action resolve all of the factual issues related to the Stuyvesant Town sale?
Yes. And there is nothing, and so it was misrepresented to Judge Maisley, and that was the error. You need to read what the complaint says. The complaint says that CWCI should have prevented the sale and conditioned the sale on a contribution because of CWCA's negligence. And it says that negligence was because of its handling of the foreclosure sale. It says that at paragraph 99, it says that at paragraph 101, it says that at paragraph 103, and it summarizes it in paragraph 108, saying that while the settlement also resolved more limited claims of the Stuytown had potentially received overpayments of interest following the foreclosure sale, any liability on that claim would have been caused by CWCA's own gross violation of the servicing standard in failing to preserve the interest rate owed on the senior loan following the foreclosure judgment. And then what does it do? It footnotes Judge Fela's decision, the very decision that was handed down 2 years later. And Judge Fela, after a 5-year litigation, 2 years of discovery, and a 100-page opinion, said she easily concluded that CWCA's actions had no impact on the foreclosure sale, and that the foreclosure sale had not changed the interest rate of the loan. It's a 100-page opinion, 5 years of litigation. She squarely decided it. She squarely decided that CWCA was entitled to the fees, and she went further than that because she entered an order saying that no holder, beneficial owner, or anyone claiming
Are the parties in this action the same as the parties in the federal action?
Nope.
No, the parties here are different. The parties in the federal court action were the certificate because
And this action is about CWCI and is about whether CWCI and CWCA violated their fiduciary duties to Cobalt under the Cobalt CDO governing documents.
there is no fiduciary duty running from CWCA or alleged fiduciary duty.
No, it's aiding and abetting.
Right, aiding and
WCI
abetting.
breach of fiduciary duty.
Right. The breach of fiduciary duty claim, which is let's be clear, there were 4 of these. The other 3 were dismissed because the breach of fiduciary duty claim is really duplicative of the contract claim. But there's no duty. This Judge Maisley, ruled, and she got rid of the conversion count because she concluded that the plaintiff has no legal or possessory interest in anything having to do with the CMBS trust that CW Capital represents. This claim is a breach of contract claim from a CDO against its collateral manager. CWCA is a tag-along. Cobalt was not in the federal court action because it's not a certificate holder in the trust. It couldn't assert a claim against CWCA for settlement if it wanted to.
So why do those claims not still survive?
Why did what claims?
Why do those claims not still survive? Why do we still not?
Because the federal court determined twice that their interests were adequately represented in connection with that litigation, and they took it to the Second Circuit. It's the only intervention case I've had in my 35-year career that went to the Second Circuit, and the Second Circuit concurred. They said that the Appaloosa, who was the main litigant in that case, was fully litigating the issues, and 2 years after the fact, they were not going to let a third party come in and just pile onto the same claims. But there is nobody who can claim through that trust either a direct interest, a derivative interest, or otherwise, which can assert that CW Capital Asset Management mishandled the foreclosure sale or wasn't entitled to the penalty interest. Now they're saying CWCI should have insisted that it was. That is a nullity. No one can make that
You are
claim.
way beyond your time, so unless you want to eat up your rebuttal
I do
time?
not.
Okay. You may proceed.
May it please the court. Jonathan Pickard from Quinn Emanuel on behalf of the respondent, CW Capital Cobalt. I want to start where a number of your honors were asking questions around the nature of the claims that are at issue here.
Right, so I'm trying to figure out what factual issues were not resolved by the federal action. And then also counsel mentioned that although the party was not in the federal action, their interests were duly covered by that act, or represented by the action.
Yes, Justice Weber, and I'd like to start there. So the claims at issue in this litigation are claims by Cobalt against its collateral manager, CWCI, CW Capital Investments, for breach of contract and breach of fiduciary duty. And then there are also aiding and abetting claims against an affiliate that benefited from some of those breaches of contract and breaches of fiduciary duty. Now, the breaches of fiduciary duty and breaches of contract that are at issue here aren't remotely addressed by the federal action. The breaches of contract and breaches of fiduciary duty that are at issue are because CWCI had a responsibility to act in Cobalt's best interest. They were our fiduciary in deciding whether to sign off on the sale of Stuytown that was going to fund this settlement that had been entered into. Now, what CWCA had done,
the issues of their own funds towards that settlement.
The only funds that went towards that settlement were funds from the trust that were Cobalt's funds.
And they didn't use their own funds.
Correct. That is
your
exactly right,
allegation.
Your Honor. They did not use their own funds in 2015 when entering into a settlement where there were allegations, a whole host of allegations about improper conduct by CWCA.
And was that issue even touched in the federal action?
No, Your Honor.
So the whole issue of whether the 2015 settlement should have even happened was not addressed by the federal court, and that really is at the core of your claims.
You are 100% right, Your Honor. Not only was it not addressed, it wasn't even mentioned. And CWCI, who was our fiduciary, who was supposed to be our gatekeeper with respect to whether this should be funded with Cobalt's money, they weren't a party. They weren't even mentioned in the federal action.
And when you sought to intervene, they opposed your application.
That's correct. And why did they oppose it?
I know, because they point to the fact that under this having started in Minnesota and under Minnesota law, whatever would have happened would have barred you, but they they barred you from coming into the case.
That's correct, Your Honor. They said this has nothing to do with this action in New York, so in New York State Court, so don't let Cobalt in. And then what do? When the decision comes out, they then go on a motion to renew in front of Justice Maisley and say, aha, this action we won't let them into has now resolved in our favor all of these claims. So there was no opportunity for us to address the court in that, and even if there was, these issues simply weren't in front of the court. The issues that are at issue here are CWCI's obligations to Cobalt as a fiduciary to make sure that our money doesn't get used for an improper purpose. The improper purpose here was funding 100% of a settlement that was resolving claims against CWCI's affiliate. And that's what this whole complaint is about.
And that is that discrete from the foreclosure?
It is, Your Honor. It is completely discrete from the foreclosure. And the fact that someday, the calculation of interest was resolved in favor of how CWCA wanted to do it in 2020 didn't address the risk that all of the parties were facing back in 2015 when there was a litigation around this that was settled. That litigation where there was $500 million that was paid to settle it, what did that do? It resolved claims challenging whether CWCA was going to get $600 million in penalty interest. It resolved the waterfront of claims at that time with respect to that issue. And CWCA was sure as heck happy to have that resolved, that settlement, right? And they were even happier when their affiliate, CWCI, allowed them to use somebody else's money, Cobalt's, to settle it. That's what's at issue here. What's at issue here is not whether it was properly calculated or not. The issue is a settlement. That's what Justice Maisley said when she denied the motion to renew. She did a careful read of the decision. She said it resolves some issues, but it doesn't resolve the issues of fact that precluded me from resolving this claim on motion to dismiss. So unless Your Honors have any other questions, I will rest there.
Thank you. Counsel, you have 2 minutes.
With all due respect, complaints aren't moving targets. This is not a complaint about a settlement. That word doesn't appear in the complaint. Read it. That when you look at the allegations that I cited to you...
Counsel, I want you to be very careful. I want you to be an advocate, but do not disrespect this court. We have read your papers, the briefs, the complaint, okay? So don't stand there and say, read it, as though we came in here empty, all right?
No.
You may proceed, sir.
Justice Maisley went back to her opinion and didn't go back to the complaint. The complaint doesn't say that the case should not have been settled, and it doesn't say it for a reason. CWCI had no control over a settlement, and they didn't plead it that way. Had they, I would have moved to dismiss 3 years ago. There's no dispute that CWCI had no control over the settlement decision. There's also no claim that the case shouldn't have been settled because counsel was counsel for the Mezco litigants. They've never taken the position that those claims were frivolous, and nobody in the CMBS trust has ever litigated that claim. We're now 7 years out, nor could they. And there is no claim in this case that it was their money that was being used to settle. Quite the contrary. 3 years ago, Judge Maisley specifically said that there was no conversion count available to them because none of the funds, they could claim no entitlement or interest in the funds that were used to settle because those were funds of the CMBS trust. So I apologize for my tone, Your Honor. It's just, I've lived...
I get it. I was an advocate too.
I apologize.
I get it.
But it just is not, I'm passionate about facts and I'm passionate about my client. And that allegation, when you proceed from the assumption that it's about the settlement, you go their way every time, and that's what Justice Maisley did. And the reason I keep saying go back to the complaint, they pled it as an approval of a sale and a contribution because of negligence, because that's the only claim that could have survived. When Judge Fela decided that question, they amended verbally, and now it's a different claim. If I'd had an opportunity to litigate the claim they're now verbally articulating, I'd have dismissed it 3 years ago because it's not supported by the contract that governs the trust, and it's not supported by the facts. Thank you, and again, I apologize. I wish you the happiest of retirements.
Thank you.
Thank you.
Leck versus Leck.
Ready. I was like, ooh. This is not going to be good.
Oh, I am so not the one. And last but certainly not least, you may proceed.
Thank you, Your Honors. My name's Howard Friedman. I am here on behalf of the appellant wife. If it may please the court, respectfully, the court below erred in granting the husband respondent 100% of the rent derived from the primary marital residence, a primary marital residence that was equally owned by both parties, 50-50, something that this court in a prior appeal had affirmed, and as well as the court below, and it's in the prenup. The prenup also provides that both parties are to share equally in the value of the primary marital residence. It goes with saying, but without saying as well, value and rent are synonymous at some point. When one does an appraisal of property, they do look at the rent and the value. Contrary to respondents' brief, they were equal owners. Somehow respondents still arguing the same point lost previously on appeal. In addition, respondent makes the claim that somehow the wife waived her right to rent because the parties didn't contemplate the rent itself. The primary marital residence was supposed to be sold promptly upon dissolution. It wasn't. The husband inserted his father into the premises to rent.
Did she have say over that rental?
Not at all. Did it without her permission, without her knowledge initially, till it came to court. And at the first motion, I believe, that's the first time she learned that the husband had done that. So there was no consent to it. Regardless, she's entitled to half the rent. As a co-owner, case after case, she's entitled to half the rent. Every decision about...
What about the expenses for the property?
So that's expressly provided for in the prenup in Article 11, that the person in occupancy of the house is obligated to pay the expenses. So he is the person, or then he put his father in there in occupancy, and he was obligated to. That was never disputed. He never asked for that money back from her because the prenup is clear that he's responsible for those expenses. So if that's the case, I can rest early because at the end of the day, she's entitled to half the rent and never waived it. If one waived it, they both waived it.
Thank you.
Thank you.
Counsel?
May it please the court, Ronnie Schindel from Prior Cashman, represent the respondent Charles Leck.
Doesn't the relief the appellant is asking for sort of follow from our decision on the prior appeal? I mean, once you say that the wife is entitled to half the apartment, doesn't it follow that she should get half the rent? And that's, we did hold that she gets half the apartment.
Your Honor, that would be 100% true, except for the fact that what she got one half of was the primary marital residence, the defined term that was in the prenuptial agreement. The wife's rights cannot be beyond what the prenuptial agreement prescribes. No one has attacked the prenuptial agreement. The prenuptial agreement is
Well,
valid.
the prenuptial agreement was silent with regard to any rent. So why should your client benefit from that silence as opposed to the 50/50 owner of the property in question?
Your Honor, respectfully, it was not silent as to rent. If you look at Section 8, sub VII, it says that all interest, dividends, and rents and other income earned are to be acquired from separate property. Okay? This is the separate, this residence.
This is marital property.
No, what is marital property, Your Honor, is the defined term, primary marital residence, the definition of which is limited specifically to what is stated in 2.2.
So what, if any, therefore, is the impact of our decision where we said that it was marital property?
The impact of your decision was that the residence to be used for purposes of that definition for to determine which residence would be the defined term primary marital residence that she would share in and get the value of, which she did. She got $1.34 million. But if you look at 2.2, it's very specific.
She said she would have an equal ownership interest in the party's primary marital.
Right, and so let's look at what the primary marital residence is. Is used in this agreement in 2.2, second half, shall refer to the equity interest in the primary marital residence, i.e., the value of the real property interest less the amount of outstanding indebtedness. It did not transfer a fee interest. What it did was transfer the right to receive a dollar amount defined by what the value of the appropriate residence was. So that is a subportion of the overall fee interest. That's it. It was just essentially a trigger. So therefore,
So if this property were sold, would she be entitled to 50% of it?
She was bought out of it by stipulation, which we point out, we asked the court to take judicial notice of, and she received $1.34 million.
So she has no further interest, your argument is, she has no further interest in that property?
Correct, because all she had under the prenup was the right to be bought out at a number equal to half.
So what was the significance of coming here and or there being a determination that it was marital property? It didn't mean anything?
What it did was resolve the dispute as to which residence was going to be used to set the value. There was
What
dispute.
about the rent paid for that apartment until she was bought out?
Again, she was entitled, the value, actually, as counsel argues, the value of the residence includes the right to receive rentals when the value is computed. There's the rents under the agreement, so she was paid for the rental value.
She's bought out. She's bought out, so she has no continuing interest in the apartment, right?
Correct.
Right. But what about until she's bought out? There was rent being paid for it, which she hadn't received half of.
The
What does our
residence
decision do about the rent until that point?
It doesn't give her any further rights because, as I said, the fee interest in the property remains with Mr. Leck. The only entitlement under this prenuptial agreement was under 2.2, which created the defined term, which says you will get paid an amount of money equal to half the value. The rent, the property itself, what the decision says is the marital property is the defined term primary marital residence. It doesn't say the London residence. The London residence remained his. He had the right to make decisions about it. And he had the right to get the rent under Section 8 because it was still his separate property. The marital property was essentially a distributive award, which she got, and the value was set by that residence per 2.2.
Thank you.
Thank you, Your Honor.
You have a minute.
By the way, Judge Mazzarelli, congratulations on your retirement.
Thank you.
Privileged to be here on your last oral argument.
Thank you very much. You're the last case.
Yes.
This is my first case.
Is it really?
Yes. So I agree with Justice Friedman that the point is we're not seeking rent from the time that the buyout occurred, but seeking half the rent up until that point.
But what is your response to counsel's argument that all that you are entitled to is half the value of the apartment. But any income it might generate or anything like that, that's not something that this prenuptial agreement gave you a right to.
But the prenuptial agreement's mutual. Then he had no right to the rent as well, would be the argument. So either they're both entitled to half the value, or neither one is, which would leave us with rent in no one's hands.
That was really, I don't know if I asked you or not, or the other gentleman, that was really my point about the expenses. Who pays the expenses?
Because the prenup expressly provides, I can read the section, bear with me a second. The party, in 11.3D, the party occupying a marital property residence subsequent to a dissolution shall be responsible for all normal carrying charges.
The period you're talking about is when the father occupied it.
I'm sorry?
The period you're talking about is when the father occupied it pursuant to the husband's lease.
Correct.
So the husband would have been, responsible for it, right? Because it was his father who was occupying the residence?
Right, so really, he had occupancy, he put his father in there, collected rent from him, yes.
Thank you.
Thank you all, and congratulations and good luck.
Thank you again.